like to mix it up a little?
Protocol is not our best.
All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning. Welcome to the Appeals Court. Does that? Yeah, that works. I am Justice Rubin, and I am fortunate, as you are, that I'm joined by two colleagues as outstanding as those on either side of me, Justice Englander and Justice D'Angelo. We will be hearing 6 cases this morning. Despite my beliefs, the rules of the court are that it's 15 minutes aside with no rebuttal. And so that will be how we proceed as usual. If any side is dividing its time, please let us know. We have notes about that, but please let us know at the outset how that division is supposed to work so we can make sure our clock is set accordingly. The first case we will hear this morning is number 23784, Commonwealth versus Lima, and we will hear from Attorney Batten.
Good morning. Greg Batten from Mr. Lima. Judge, I'll rest on the brief unless the court has any questions.
Oh, I think we're going to have questions.
I have plenty of questions. Yeah. Someone walks into a pawn shop with a stolen guitar. Possessing the guitar is not enough to show that he received stolen goods or possesses stolen goods. What is enough? People pawn stolen stuff all day long at pawn shops, and in fact the police, it turns out not without cause, distributed a flyer to pawn shops about these very stolen items. So what do you need aside from, I've got a stolen thing and I brought it into the pawn shop, let's say temporally close to the theft, this is a few days after?
Sure. I'll refer the court to the Cromwell decision out of this court, the Kirkpatrick case. So I think what the government failed to do, yes, the guitar was stolen, yes, it was brought to a pawn shop within short order, but I don't think the government, I know the government did not show the actual circumstances, the arrangement, or the understanding under which Mr. Lima possessed the guitar.
That's because they don't know what it is, let's say.
It doesn't really matter. I mean, the incriminating evidence behind his possession, so he has the guitar.
They don't have to show that, do they? I mean, you said in your brief that an element of the claim was that someone else had to have stolen the guitar. And I took from that the Commonwealth had to prove, in your view, the Commonwealth had to prove that the defendant didn't steal it. But I don't see any case law that says that.
Judge, I didn't say that in the brief. I said the government's burden is to prove the actual knowledge that he knew the guitar was stolen. If he stole it, then it wouldn't be a receiving stolen property.
Well, we don't have a way of getting at knowledge all that well. I mean, sometimes people say stuff, but so we have to figure out what evidence demonstrates knowledge, and I'd be concerned about a rule that says you can never arrest someone who pawns a stolen item. That doesn't sound right to me because it happens all day long.
Sure, but how do you know, how do you impute the knowledge to the individual?
Okay, so that's what I'm asking you. All right, let's assume we can't figure out who stole it or how the guy got it. But he's got it.
He's got it.
Does it make any difference to you if he has possession of other items from the same robbery?
It would be a factor to consider, but again, the second guitar was not established how he came into possession.
I understand that, but it's a factor, you say.
It's one small factor.
I mean, I've had cases, a guy brings a watch to hawk it, and he's got 10 other watches, and they were all stolen from the same place.
Well, I don't know if you can impute knowledge to him about stolen from the same place. My problem with this case was the government didn't establish how he came into possession or the circumstance under which he came into possession.
Well, he doesn't have to incriminate himself, so they're going to have, if they haven't solved the robbery itself, they're going to have a hard time doing that. If for some reason they apparently don't think he's the thief, he wasn't prosecuted for that.
I understood, but the second guitar comes into play at a later date at the pawn shop. When he came into possession of that guitar, It was unclear for me from the record, but going to the pawn shop with it isn't enough to establish that he knew the property was stolen. So all the items that were taken from that house, 2 guitars, go to pawn shop, the same pawn shop on 2 different days.
But he certainly obtained them after the robbery and before he brought them in, right? So one of them he had 3 days after the robbery.
He had it. I don't know when he had it, but he had it.
And what are the hypotheses that we need to eliminate? What are ways that people could find themselves in possession of a stolen guitar?
Can't answer that question, Judge. I don't know. It might be on the side of the road.
Might be on the side of the road. 2 of them?
There might be 2 of them, and there could have been 4 of them, and he took 2. It could be leaning up against the side of a house. I really don't know, but again...
Counsel, what do we do with Commonwealth against Kirkpatrick, written by, Justice Graney? The judge instructed the jury that if they found that the defendant was in possession of recently stolen property, they could draw the inference, if they chose to, that he knew the property was stolen. That's an instruction, and then the court does not say that instruction is wrong. In fact, they say the inference permitted by possession of recently stolen property can be a strong one.
Sure.
It may act as a substitute for direct proof of guilty knowledge. I mean, isn't that basically enough? Doesn't that mean we'd have to overrule Kirkpatrick to rule the way that you want us to?
Absolutely not, Judge.
Why?
Because Kirkpatrick doesn't stand for merely that proposition. I cited at the end, Kirkpatrick, the evidence established a reasonable basis for the jury to infer the visible effects after the boat was stolen.
There's no question there was more evidence in Kirkpatrick, but my difficulty is there was an instruction which they lay out. The judge says that inference can be a strong one. If the instruction was wrong, they'd have to reverse, wouldn't they?
If the instruction was wrong, they would, but the instruction, this was the factual predicate for the jury to draw that inference based on that instruction was not present in this case. It was
sure
present.
It is. Isn't it recently stolen property here?
Not enough. The factual predicate in the Kirkpatrick case goes into all sorts of matters that this individual took on to crudely repaint the boat.
I understand your point, and I take it that there was more evidence in Kirkpatrick. But if the instruction is wrong, that's a problem. The court never says the instruction is wrong.
I'm not agreeing with the instruction. Obviously, the instruction's been laid out. The jury's free to infer recently.
Do we know if it was challenged even on appeal? Knocking out that instruction, well, maybe that would have helped him, right? If the instruction is no good. There's a lot more evidence than just the timing, though.
And that's the point I'm trying to make to the court in this case is the recently stolen guitar, he's in possession of it. I don't dispute that. He's at the pawn shop. But what colors in, what incriminating evidence colors in?
All right, so let's
The fact
move
that
to
he's
the...
trying to sell it after it's
That's
been
not
recently
enough.
stolen?
Judge, that's not enough.
All right, well, let's go next to the...
Sorry,
I mentioned that in a footnote. Going to a pawn shop isn't in and of itself a crime. I mean, the negative connotation behind that.
No, but the combination of the fact that it's recently stolen and then he's trying to sell it, doesn't that give rise to an additional inference?
Not in my view, because I have nothing to support that he knew at the time he possessed it, that the guy...
How about the value of the guitar? How about the fact that there are 2 guitars? Because we're sort of ignoring those. Those are factors, aren't they?
The 2 guitars are facts. The 2 guitars being presented at 2 different dates at the pawn shop are facts. The value of the guitar was set by the individual who allegedly lost the stolen guitar. The pawn value was not set up by Mr. Lima.
So if he had been on the street selling the guitars for $10 each, that would be okay. That would be
I would have a problem with that in fairness because the value of the guitar is $2,000. He's in possession of it at the time he's selling it, and I've referenced cases that support we're undervaluing.
What does he get? What's the pawn, $50?
The pawn shop set the price for him. They gave him,
What does that mean, set the price for him? They said, we'll give you $50. He didn't have to say, I am locked in, here you go. He could have said, this is a $2,000 guitar, thanks, I'm going to go to maybe a music shop.
But he didn't say that, and I would think that really what really diminishes the pawn shop issue is the fact that he provided truthful information about his identity, social security numbers, dates of birth.
It is a very odd way, it is an odd way to get rid of a stolen item by giving
think-
them your name and social security number.
I think
Go
you
back
have
to my question. So we have 2 guitars. I know you want to distance yourself in some way about the value, but the value that he gets for the guitars is seriously undervalued, and there are two of them. So there's three factors right there: recently stolen, two of them, and undervalued.
I disagree. Recently stolen, yes. Presented to the pawn shop on 2 different dates, 2 different guitars, yes. He got nothing for the second guitar, so that was no value set on that. Nothing came up about that in any way, shape, or form.
That's because they knew it was stolen.
They knew at the time after they presented the second guitar, and that's when it was reported to the police. But Lima going in with the second guitar after giving all the information prior, we're not going to.
No, I understand, but it's not that they couldn't agree on a price. It's that they said, we can't take this guitar.
Understood, but they gave him the guitar back and he left. I mean, that to me does not support an inference that he knew it was stolen. And neither does the price that they set at the time when they gave him the $50. And then when he went back to pawn the second guitar and they gave him additional, I guess, for a total of $186, that to me doesn't set the tone. I just don't think you have enough.
What do you think is your best case?
Cited, or I think the Cromwell and Kirkpatrick cases that lay out the factual predicate so a jury could infer that recently stolen property, the person knew it was stolen because of the changes and the attempt to camouflage, going in and trying to make it look different than it was. And that wasn't even the case here. When the guy got the guitar back, there were no changes. The serial number wasn't obliterated. Everything was the way when he was stolen, it was in the same condition as when he got it back. Any other questions for the court?
I see none. Thank you very much for an excellent argument.
Thank you very much.
We will hear next from Attorney Hunt.
Good morning, Your Honors. Brandon Hunt for the Commonwealth, and may it please the Court.
Was the instruction correct in Kirkpatrick?
The instruction was correct in Kirkpatrick. It was. Here as well.
Jury can be instructed, you can infer solely from the fact that property has been recently stolen, that the person in possession of the property received stolen property.
I believe that that inference is proper and
And the
reasonable.
word recently means what in that context?
In Kirkpatrick, recently meant about 8 months. Here, it means 7 days.
Yeah, but that's what the court had, that was the whole problem the court had, right, in Kirkpatrick. They said, 8 months, that looks like a really long time. Jury probably needs to be instructed, that's too long.
Right. I agree that 8 months is
All right, so maybe 8 months isn't any good. What happened in Kirkpatrick is they had a whole lot of other evidence, right?
Right. There was a.
But is a week?
I'm sorry.
A week? That's what we have here, right? A week?
That's what we have here. A week. Yeah. 7 days. 7 days from the time that it was stolen at Mr. Cross's home, and when the defendant entered the pawn shop to pawn that guitar.
So the instruction in Kirkpatrick in that case was not correct. But the court let it go because of the evidence. Is that the way to read the case? Part of the reason I'm asking you is because I notice you really didn't sort of sit hard on that language in Kirkpatrick in your brief. You argued it a little differently than I expected.
Right, and I think the instruction given in this particular case is enlightening because the judge talked to the jury, presented to the jury, and stated that actual knowledge is necessary. The time frame is, as we said, 7 days, but going to knowledge, the judge stated a prudent person that would have known or should have known that the property was stolen is not sufficient. It needs to be actual knowledge.
So what was the evidence of actual knowledge in this case?
So I argue that the Commonwealth met its burden to overcome the required finding because there was peculiarities around the situation where the defendant entered the pawn shop, sold it for, first used it as collateral for a $50 loan, returned 5 days later, was it 5 days later? 6 days later, excuse me, to sell it outright for $236. The guitar itself was a unique, and as testified by the Mr. Cross, the owner of the guitar, that it was a rare guitar. It was a 19.
Doesn't that again, I hate to use the word inference, but doesn't that infer that the defendant knows about the guitar being unique? What if he bought it from someone else? I know I'm playing this out, but I'm a big fan of eBay. And I go on eBay all the time. I love pans, and I find all clad pans that are like $20. Says new on it. Am I supposed to know that that must be a stolen all-clad pan just because of the price?
I think facts that would add, such as Your Honor's facts, I think that that would negate, the peculiarities here, but that was never brought up in this particular case, and 7 days is not sufficient time to order something off of eBay, receive it, and then turn around and turn it.
I just threw that out, but I'm trying to figure out what is the uniqueness of the guitar have anything to do with his guilty knowledge? Because that's what you have to show. I mean, it's actual knowledge, but it's guilty knowledge that it's stolen. Why does the uniqueness matter?
Yeah, I appreciate that question because, I mean, I'm not a dealer in the market for guitars, but based on, preliminary knowledge and reading the transcript of the case, the market for guitars is limited. This was a rare guitar. It had a unique sunburst
None of that
paint.
came from the defendant. That all came from the pawn owner. So I buy my son a guitar, a Gibson. I bought it. I know the value of it. 20 years later, he needs money, and he goes to a pawn shop. He's never looked up anything. He just goes and sells the Gibson. That guilty knowledge can be inferred by him because how? It's an old guitar.
I agree with Your Honor that at that point that's tough, but here we have a little bit more for the peculiarity surrounding the events here because the defendant returned either the same day that he sold the guitar or on December 1st, 6 days after. There's discrepancy there in the testimony. But he came back with a second guitar that was also stolen from Mr. Cross's home. And I think that those factors weigh heavily in the judge's decision.
So if you possess a stolen item, the law says that's not enough to prove that you know it's stolen. But if you possess 2 from the same robbery, that is enough?
Not entirely. I believe that there's other circumstances and other factors that need to be considered here, such as the peculiarities surrounding the transaction, the considerable underevaluation.
Other than the fact that it's recent and that he sold it for 1/10 of the supposed value.
So again, here it's the timing, 7 days.
That's what I said. Okay, so it's close in time.
Close in
to
time.
the actual theft.
Marketability of the guitar, substantially under-evaluated.
What do you mean marketability? It seems highly marketable, doesn't it?
It is. It's a highly marketable guitar.
Okay,
and
but
it
so
was valued over-
he takes $236 for it, or whatever it is, and it's a $2,000 guitar. So one of 2 things is going on, I guess. Wow, this is stolen. I better get rid of it quick, and just if I can get any cash out of it, I'll get that. Or I don't know how much it's worth. Maybe because it's stolen, or maybe for an infinite number of other reasons. Maybe I have some baseball cards at home, and one of them is Mickey Mantle's rookie year card. But I don't know much about baseball, and I don't know what year maybe I never heard of Mickey Mantle. You're younger than me. Maybe you've never heard of Mickey Mantle, but still, you haven't heard of Mickey Mantle? No. Oh, my God.
Move on, Justice.
I'm too.
That's the worst thing I've heard in so long.
He was a
Hold that against
baseball player. So, all right. So, I'm sorry.
You lost
totally
your train
lost
of thought. I told you flustered.
His card would be valuable. So, but I might not know that because I know nothing about it. Maybe it's a shoebox my brother left in my closet when we were growing up or something. And baseball cards, people like those. Maybe I can get $40 for this or whatever. We have to get to beyond a reasonable doubt.
Right.
And I'm just not sure how It seems to me that selling it for too little could mean so many things. And I'm not even sure a thief, I mean, of course, I don't know, if a thief knew it was worth $2,000 and he went someplace and someone said, I'll give you 200, he might say, wow, I got to get rid of this, it's hot. Or he might say, what are you kidding me, this is a $2,000 guitar. You know, I don't know how we get to, I'm not saying it's not beyond a reasonable doubt, but it's a tricky case.
Is your opponent actually did put in his brief that he had to know, he had to, that the Commonwealth had to prove that, as an element, that the defendant did not steal the guitar. That's not an element of the claim, of it, right?
The elements here for receipt of stolen property are that the property was stolen, that the defendant knew it was stolen, and that he knew that the stolen property was in his possession.
Yeah, I noticed the jury were not instructed that he had to not be the person who stole it. But is that really, it's receiving stolen property, not possessing it, right?
Correct, yeah, it's receiving, not possessing.
And what's the difference?
I mean, once you receive it, you're in possession of it. That's plain and obvious. But here, I mean, the disputed element is the knowledge that the property was stolen.
No, I agree with that. I agree with not. I'm just asking for my own edification. If you steal it yourself, did you receive it or you took it or something?
No, there's a distinction there, because if you
Be careful. I mean, I'm not sure. If it's not an element that you have to prove that you didn't steal it, then I'm not sure that you can't receive the property that you stole. I mean,
we know you can't be convicted of both, right? We've seen
Yeah.
cases where
Yeah.
someone's been convicted of stealing and receiving, and the courts have all said, like, no,
Right.
those aren't. You can't do both.
right.
But I was unaware that you could do receiving by being the thief. But that's not an issue here. No one's raised it.
Right, and that wasn't what the defendant was on trial for. He was on trial for receiving stolen property.
Yes, I agree with that.
The thief is often charged with receiving because it's easier to prove. As a former prosecutor and defense lawyer, we can admit that, right, Commonwealth?
Correct, yeah.
Okay, so now let's get back to the factors, because I am still having some trouble. I know these are difficult cases to prove. And back to Justice Englander's, I think his first question, the inference that you need to draw has to be there, or else you lose.
Right.
I mean, that's fair. If we came out of, and I'm not saying we would, but if we said an inference isn't enough, you're out of luck. You would agree with that, right?
Actual knowledge is difficult to prove with direct evidence, and so the Commonwealth, I would argue, presented sufficient circumstantial evidence to at least overcome the motion for a required finding and send it to the jury.
This is where I want to really cement it for us. The evidence that you say carries the day for the inference to be permissible is recently stolen, the marketability, and the value. Because marketability is sort of different than value. I think in your brief you used the uniqueness. I'm sorry. Uniqueness and marketability equals value.
Correct.
Those are the sort of the three things. And a fourth, which may not be in most cases, is the second guitar. So let's put that one aside, because in most receiving stolen property cases, those are the three things.
Correct.
Okay.
That is.
I don't really understand the uniqueness argument. I mean, first of all, without getting too metaphysical, every guitar is unique. But this one is unique in the sense, well, they are. This one is unique in a funny way, which is it's missing stuff.
Correct.
It's missing a pickguard, it doesn't have the original Les Paul knobs, and so on. Somehow it's still worth $2,000. But you can imagine someone saying, well, this is an old beat-up guitar. I don't know what I can get for it. What do you say, $236? Okay. Right? Doesn't its uniqueness actually undermine the knowledge because of the way in which it's unique?
I mean, I could see it going, factoring that way as well. However, I think that the uniqueness here in the guitar sense, that it was missing a pick, that it was so altered by the owner, and he testified that he made those alterations because it was easier to play and manipulate the guitar and use the guitar. I think that a guitar owner would understand that, and it would be universally accepted that those alterations would do.
I don't know how it shows, and this is just Rubin's question. Why does it show that he had knowledge it was a stolen guitar? The fact that it's beat up. Actually, to me, I agree with this. It detracts from the inference that he knew he was getting a lot less than it was worth, right?
Right, Your Honor. Also, to push back a little bit, I wouldn't claim that it was beat up. I mean, it was still in a workable, nice condition. Yes, it had markings where it was sitting in the guitar holder stand, but it was altered to make it easier to play, and that was testified during a trial. And so beat up, I think, would be an overstatement here. It was still a nice guitar.
So we have
owner.
He had possession of it shortly after it was stolen. He tried to sell it shortly after it was stolen, which I think is relevant. And he tried to sell it for much less than it was worth. And he had two of them. All right.
Hypothetical, I know you hate them.
I love hypotheticals.
What if there wasn't a second guitar? Would the three that we just went over be enough? The recently stolen and trying to sell it recently, uniqueness and marketability. Would that be enough?
I think that would be enough to overcome a motion for required finding, to send it to the jury.
Why does possession of 2 items from a robbery prove anything more than possession of 1 item from a robbery?
I don't think that it proves
Or strengthen the inference?
it does strengthen the inference, because here I think it's unique. These guitars are heavy. They are altered. One was stolen significantly, like as Your Honor mentioned, 1/10 of what it was worth. They were both stolen from the same residence, and he came in with a second.
What's really going on? Why does he, I imagine there's probably no evidence as to this, but if you have an insight, it might be useful to me. Why does he kind of do this serially? He goes, he pawns it first, then he comes back and says, no, I want to sell it. Is there something going on there in terms of why a person in possession of a recently stolen item might do it in that fashion?
There was some mention in the prosecutor's closing arguments, some speculation that the defendant was just testing the water, so to speak, coming in to, use it as collateral, 7 days later, or 6 days later, returning, selling it, and then coming in with a second guitar just to ensure that that he could do it.
Your time has expired, but if there are seeing no further questions, thank you very much for another excellent argument. The case is submitted. The next matter that we will hear is number 22558, Commonwealth versus Timothy Brown. I do see that this is partially impounded, although I'm not sure what the scope of that is, but I assume counsel will be, and that you will not share impounded material during argument. And with that, we will hear first from Attorney Mirsky.
Good morning, Your Honors. Attorney David Mirsky for Timothy Brown, and with me at my table is my partner, Joanne Petito. There's a pending motion to extend the record that I filed last week. I'm not sure whether the court ruled on it. It looks like the court may have, without indicating, because the transcripts are listed on the docket that I submitted.
What you want to do is submit the transcripts from the criminal trial?
Yes, Your Honor. The transcripts that were on file at the SJC, and I had assumed that the courts could access those, but I found out that
So this is from the earlier stage of this appeal when it was before the SJC.
Yes, Your Honor.
I don't know if we have ruled on it. I don't know if we've seen the motion. So
I've seen the motion, yeah. I mean, but I
don't think we've
can't, I can only speak for myself on this panel.
Yeah, all right.
which
So
is-
so
I don't
let's.
see a problem.
It sounds like there wouldn't be a problem, but let's not rule on it from here. Let's just go ahead with your argument.
Yes, Your Honor. This is an appeal from resentencing in the Superior Court, in Middlesex Superior Court. The case is controlled by federal law.
And which issue do you want to start with? Do you want to start with the issue of whether or not it was appropriate for them to make the decision prospectively only, or not?
I can handle that.
Well, what would you like to start with?
I think that's important, Your Honor.
When you say it's controlled by federal law, what would you rely on for the proposition that this particular decision by the SJC with respect to how malice is to be proved, or how first-degree murder is to be proved, would have to be applied to the person in front of them? What case would you rely on?
Well, it's a few cases joined together, Your Honor. First of all, Mr. Brown is not convicted fully under federal law unless he's been sentenced. So at the time that he was in the state of having come down from the SJC with having the murder convictions
So what
vacated.
case would you rely on for that proposition, that he's not been, quote, convicted fully under federal law until
Burton
he's been
versus
sentenced?
Stewart.
Sorry?
Burton versus Stewart. It's cited in my reply brief.
All right, but look, the problem with this whole argument is unless, and even if you we're bound by what the SJC says, right? We're the appeals court. The SJC has ruled not just in the abstract, not just in announcing a rule of law, but in this very case, they have ruled you get no benefit from our change in the law. I'm not saying I think that's fair. I'm not saying anything about the merits of it. I'm just saying we have a holding of the SJC that says this is not prospective. Now, if you think that raises a federal claim, maybe you can go get habeas in the federal district court. If you, Teague is not involved because it's not a constitutional rule, but I understand there could be a due process or other kind of claim you might be able to bring. But we have the SJC telling us this is not prospective only. So if we find ourselves bound by that, and frankly by the sufficiency conclusions that were reached below, what we're facing here, even assuming the case is still alive, is a series of waived claims. Claims that could have been brought before the SJC, but were not. Now, waived claims are ordinarily, and maybe I should sort of just stop here, because you know the standard of review is substantial risk and so on. But the question seems to me to be, if you have a waived claim in a case like this that I'm willing to call alive for purposes of a bunch of things, we're hearing the appeal, it's not a collateral attack, so it must be a direct appeal, and okay. Ordinarily, if you had failed to make an argument before the SJC and you wanted to make it before us, you'd go file a motion for a new trial, you'd raise it there under the appropriate standard, and it would be appealed eventually to us and maybe the SJC. Instead, you're raising it here. Is that procedurally appropriate?
Yes, it is, Your Honor, because first of all, in the appeal, in the direct appeal of which included the first-degree murder counts, the court was not ruling on Mr. Brown's conviction of second-degree felony murder. Actually, they had the case because of the first-degree murder indictments, and
Do you want us to reinstate the original conviction?
No, Your Honor, and you can't do that because those have been vacated.
Wait,
So-
what's been vacated?
First-degree murder convictions by the SJC.
Okay.
Under General Laws 278, Section 33E, the SJC has jurisdiction over the first-degree murder charges, which they vacated.
Can you
And
tell
they're-
me,
and-
can you tell me back to part of Justice Rubin's question? The SJC ruled on it, that this is not to be done prospectively.
Well, that
What-
was a concurring opinion, first of all, Your
It's
Honor.
not a concurring opinion. There are 4 votes for it. It's a majority opinion that's listed as a concurrence. It's a majority of the court. There's a holding in the Gantz opinion.
Well, not only that, they've treated it as a holding in whatever the case is, Martin, right? I mean, we have precedent from the Supreme Court directly on point. It says you're trying to make use of this with respect to a prior appeal. I say directly, but it's not
I mean,
directly.
the Supreme Judicial Court of Massachusetts,
Yes.
not the Supreme
Yes.
Court of the United States. The Supreme Court of Martin, made what I consider an error of interpretation of the United States Supreme Court case of Fiore versus White.
Are we allowed to overrule the SJC?
You are bound to apply federal law and to interpret
Are
it.
we, if the SJC makes a ruling of federal law, are we allowed to ignore that? Or are we bound by the rulings of the SJC? We're certainly not bound by the rulings of the First Circuit.
You're always bound by the rulings of the United States Supreme Court.
I would agree with that.
Yeah, I guess I
I'm
agree
not
with that,
sure. I'm not sure that everybody would agree with that on this court, but I would agree with that. But the problem is Fiore's clearly distinguishable, isn't it?
Your Honor, I don't accept the way that Martin distinguishes Fiore by claiming that there's some kind of mere clarification by the
That's
Pennsylvania.
exactly what, so the U.S. Supreme Court went through the right process. It said, hey, are you construing the way this statute has always been, or are you making a new rule? And they said that to the Pennsylvania Supreme Court, and the Pennsylvania Supreme Court said, that's the way it's always been. And then the court said, well, then this is easy, because they didn't prove it. But this is a different case. Our court has looked at exactly this issue, and our SJC, and they've said, it was constitutional at the time, and they proved it at the time, and now we're going to change the rule going forward.
Our SJC has ruled that second-degree felony murder cannot be the basis for a conviction without proof beyond a reasonable doubt of actual malice.
Sure, assume for
Common
all
rule going
trials
forward.
starting after the day that this case was decided.
However, Your Honor, Mr. Brown did not have a conviction of second-degree murder, felony murder, when he was before the Supreme Judicial Court.
But-
And he
well,
did, and at the time, and the reason I cite Fiore is because the important thing about Fiore is that the court's saying we don't even have to look at retroactivity because there's no, it's not even necessary to reach the holding that due process is violated by convicting a person of an offense that doesn't exist. And that,
Do you have to exhaust state remedies before you seek a federal habeas?
yes, Your Honor.
Has this issue ever been exhausted in the state?
It's not exhausted yet, Your Honor.
Thank you.
Yeah.
And that,
Can we just go back to something that you said, because I think this is the nub of what you're trying to tell us, and I'm not yet getting it. When your client was before the Supreme Judicial Court, he did not have a conviction of second-degree murder.
yes.
That's your point, right? That's the key to where you're headed, but just
It's
play that
not
out
the
for
key,
me.
it's just an answer to the question, why can this court address it? This court regularly addresses cases brought as first-degree murder indictments that end up in second-degree murder convictions, and they come straight to the appeals court. They don't go straight to the SJC.
Are the elements of second-degree murder, were they found, is it a lesser-included offense of first-degree felony murder? That is, if the jury found first-degree murder, do they necessarily have found the lesser-included offense of second-degree murder, or no?
No, Your Honor. No.
So when the SJC said,
We're
"We're
talking
going to
about.
call you convicted of second-degree murder," were they really just monkeying with the sentence? Like,
Your Honor,
it's a funny
they
way
made-
to...
You can see from the decision that it's a divided court coming to agreements and making compromises in their language, and yet there's a person here, and there's a conviction, 2 convictions of murder vacated, and he comes back to the Superior Court with, faced with sentencing, life sentences with parole for an offense no longer in existence, and that has to be something this court can address.
And that's what 33E review is in the SJC. They can reduce a first-degree murder, correct?
It's not that, 33E is not now part of this case because there's no first-degree murder convictions.
It's how you got here.
That's how it got here,
Yeah.
Right?
right?
Yes, it got here because the SJC did not do the normal thing when substantive law is changed and apply it to the person who's before them, who's giving them the reason for changing that law. And those reasons are in the facts of his case.
Okay, so
Your argument is
let me
that
tell you, I agree with you that there's something wrong with that. I think there's something seriously sort of confused about saying there's a new rule going forward, but this person who raised it right here doesn't get the benefit of it. Seems, I've never seen something like that before, but there it is. How can we do anything about it? I mean, obviously you can seek FAR, although you also sought reconsideration, and they showed no inclination to do anything to alter this. How can we do anything about it?
Because under federal law, which you're bound to apply, Mr. Brown had not been convicted of what he's being sentenced for now and what he's appealing now. And you're the court that has the power and the duty to apply federal law and to adjudicate an appeal of a person convicted of second-degree murder. The SJC is no longer in this case as they have done their job.
They're always in our case, right? I mean, their holdings bind us. I understand your point about it being federal
Not
law.
always, Your Honor, because I've had a case called Commonwealth versus Forish, where the SJC refused to take further appellate review. The U.S. Supreme Court granted, vacated, and remanded, and then this court applied that decision by the Supreme Court.
Well, of course, and a denial of FAR has
And it didn't go
no...
back there because the Commonwealth
Didn't see.
accepted the rule of the law of this land, that it's set down by the U.S. Supreme Court.
But that, I mean, all of this argument hinges on your concept that, I mean, I think I'm wondering whether there are 2 pieces to it, but your concept that there's a federal law that prohibits, the Constitution prohibits the decision that the 4 members of the Brown Court reached with respect to the prospective application. And the best case you have on that is Fiore.
Well, I believe the best case I have on this is actually Brown, because the Supreme Judicial Court cited that it was protecting the rights of the government by not making this case prospective, apply to Mr. Brown and making it prospective only. And the Constitution and the Bill of Rights are not there to protect the government. They protect individuals.
Well,
And that's why I'm
they
here.
weren't saying they were protecting the government. They were saying, we're going to change the law, which individuals in your client's position think is a good thing. We're going to change the law, but we're acknowledging that when this case was tried, it was tried under a different scheme. And under that scheme, the Commonwealth may have made a choice.
What choice? To not include evidence of actual malice that they had? What was the choice?
Yeah, that's exactly right, that
Well,
they didn't need to.
That shows that they lacked the evidence.
Did not have to.
They
The
did
law
not
said
have
that
the
they didn't
evidence
have
to
to.
convict.
Right?
They know that they give their evidence in a murder case, a first-degree murder case. The Commonwealth comes forward with all their might and all the weight of the state. And that's why the state does not get protected by the Constitution.
Presumably you have all of their evidence as well, right? I mean, because of Brady, you've seen everything they have.
Brady doesn't say that.
Okay. I
Post-conviction
agree with that, but everything exculpatory, I think good lawyers turn over pretty
It
much
requires
everything.
subsequent litigation and findings and discovery from,
Did you raise this argument below? Did you ask the trial
I
court?
raised that, I could not raise that second-degree murder could not be the basis for Mr. Brown's conviction.
Why couldn't you raise that?
In the SJC, because it wasn't an issue, Your Honor. We were there to decide first-degree murder.
No, on remand, did you raise it?
At the trial level, after the SJC reached the decision and said it was second
I'm
degree.
raising it here. This is the appeal.
Yeah, okay, but you had a remand in the trial court. Did you
had a
raise it?
resentencing.
Did you raise it there?
It's been raised, yes.
Did you raise it there?
It was raised by counsel. It was part of the sentencing argument, not a motion for new trial. It's sentencing
But
argument.
not, and also
Applying these-
not an argument that this is a live case, it's back here, what they did was wrong, you should undo
Why
it.
would
as-
they need to say to a court
so
that's
that you-
sentencing
so
them
that
that
you
this is a
could-
live case?
so that you can
It's a
appeal.
live case. He's getting sentenced
I'm not
there.
asking you if you said it was live, I'm asking you if you argued below that the second-degree murder conviction couldn't stand. Did you argue that in the trial court? Because you're on appeal from a trial court, and we treat claims that were raised differently from claims that were
Well,
not.
Your Honor, no matter what, if a claim doesn't exist, and this is why, and if a crime doesn't exist, this
No,
is
it's a
why I cite
substantial risk,
Fiore.
I agree.
Then it is a violation of the Due Process Clause of the 14th Amendment to convict a person of that, because it doesn't exist.
But that's not what the SJC said. It didn't say you're convicted of second-degree murder. That's not what it said.
They haven't even had this case yet.
No, what the SJC
Excuse
What
me.
the SJC said, as I recall reading it, and you can correct me if I'm wrong, is he's been convicted of first-degree murder properly under our law. But our 33E review allows us to say second-degree murder and send it back for resentencing on that ground. That's what they said, right?
Well, what they said was...
Are you saying that's unconstitutional?
What I'm saying is what they did say was specifically on the facts of this case that Mr. Brown was on the remote outer fringes of a...
You're not answering my question, which is actually
but-
something I'd like an answer to. Are you saying that what the SJC did with their 33E review, when they said he's been convicted properly of first-degree murder under our laws, however, using our 33E review, we can reduce that to second-degree murder, are you saying that is unconstitutional under the federal Constitution?
No, I'm saying to sentence him now. I'm saying the SJC could definitely, under 33E, vacate his first-degree murder convictions, which they did, and which this court has no power to reinstate. However, what they also did was vacate the crime and eliminate the crime of second-degree felony murder.
So your whole claim, I mean, there actually are some other
There's a lot of other
claims about
claims,
home
Your Honor.
invasion and what
I don't waive
merges and
anything
what to
in
know.
my
Of course
briefs.
you don't.
Or the-
And we
or the
have your
supplemental
brief on all of those. But your claim here is that is about the prospective only rule.
That's what we're talking about, but there's many other things
No,
we
of
could be
course.
talking about. And also Gardato, and there's some overlap
Yes.
in that, too, because,
This is a very complicated case. You're 5 minutes over time, though. I don't want to.
I'm sorry.
No, it's not your fault. We've been asking you questions, and you're allowed to answer them. Thank you very much. It is a
Thank you, Your
complicated
Honors.
case, and that's an excellent argument. And we will hear now from Attorney Johnson, and we've given your brother additional time, so if you need it, or we demand it, we'll give you more.
Good morning, Your Honors. May it please the Court, my name is Melissa Johnson, and I am an Assistant District Attorney in Middlesex, here on behalf of the Commonwealth. not really sure where to start here. I've been doing this as a prosecutor for 20 years, and I have to say I am really at a loss here about what to say to the defendant. I don't remember how many times I used the word "estopped" in my brief, but that is what this case
Okay,
is
so,
about.
but your brother says there might be a federal issue, and that we are bound by what the Supreme Court says, and it doesn't seem to have been addressed in the first go-round at the SJC. So let me ask you this. You agree that if well, I don't know if you agree with this. If during the pendency of the appeal of the SJC, the legislature had abolished felony murder, you agree that his conviction wouldn't stand either as first or second degree felony murder if the legislature done exactly what the SJC did?
Not necessarily. If the legislature had done that, if they had abolished the crime altogether.
Yep.
Then if they're abolishing it, then there is no crime for which he is serving
That's
a
right.
sentence.
I agree with
However, that's
that.
not what happened
I
here.
understand. I'm asking a hypothetical. All right,
How
now,
much different is it?
It's different here because what the SJC did is they reduced his sentence, his conviction, his verdict from murder 1 to murder 2, not necessarily felony murder 2. If you read the Paulding case, which I cited in my brief, even though this case on the facts may not fit with the verdict that the SJC has determined is consonant with justice, under 33E, the SJC still has the power to do that.
okay, but I'm talking about the prospectivity of it. So now let me change my hypothetical a little bit. They hand down their decision, they don't do what they did in Brown about felony murder, but they say everything the same about 33E and what's really fair, and they reduce the, I guess, I don't know how you want to put it, but they remand for resentencing.
Yes.
While the remand is pending before the hearing on it, 2 days after the SJC decision,
Right.
the legislature now abolishes felony murder and says you have to prove actual malice, you can't compensate by using the commission of this other felony. And now it's before the judge on resentencing. And the defendant files a motion that says, Your Honor, I know we're here for resentencing, but this crime has been abolished. It doesn't exist anymore. And this isn't a collateral attack. This is part of my direct appeal, the remand from the first time. Please vacate my conviction. Does the trial judge have to do that?
No, they don't, and I would take it up if they did, Your Honor, because the issue, the analysis is the same. What this court or the SJC would do is say, is that previous statute under which he's been convicted constitutional?
No, they wouldn't. They'd say there is no such crime.
That does not exist.
This crime no longer exists, and our general rule is everyone who's on direct appeal gets the benefit of that, and his direct appeal isn't over because we remanded it. It's got to go through the trial court, back to the appeals court, and if we grant FAR.
But that's not what happened in this case.
I'm not asking that. I'm asking whether that would be a good claim or not a good claim. I think it would be, but I don't know what.
I think I would take that up and ask the SJC or this court, wherever it went to say, was what he was convicted of before constitutional? Was that constitutional?
Can I bring this back to this case for a
Yes.
second? Because I don't think that's what the defendant's argument is. I think the defendant's argument is, whatever the SJC did, they did. But when they exercised their 33E prerogative,
Right.
they turned the first-degree conviction into a second-degree
Yes.
by felony murder.
Yes.
And he's saying that at the trial court level, he was never convicted of that. So therefore, he cannot be sentenced on that because that's not what he was tried for. It actually sounds like a good claim, but that's because of the SJC's 33E review. And I looked, and I can't find anything like that in the history of 33E.
Right. This is an unusual case, I understand, but Paulding controls here.
Paulding is what?
Paulding, in my brief, talks about the fact that, yes, the SJC can reduce a verdict, even though the facts may not be completely consonant with that verdict. It's perfectly fine because the SJC has the ability to do that if it's consonant with
That's an
justice.
SJC decision?
Yes,
They
And-
can reduce the verdict.
yes.
The defendant's argument here is they didn't reduce it, they changed it. And I'm because now we're getting into lesser included. If you reduce a verdict, it seems to me what that kind of means is you make it a lesser included offense. Reduce, right?
Not in this instance.
Tell
I
me why
understand.
in this instance that's
Okay.
not what it means.
Because what the SJC is doing in its power under 33E, it's not distilling, it can, it didn't in this case, it can distill the evidence and decide what is more consonant with the evidence, although in this case, as you all, your honors have said, the evidence here actually supports a first degree. But they also have this power to reduce the verdict if it's consonant with justice, and that doesn't really involve this kind of distillation of what are the lesser included crimes here? How much evidence is here? What is less?
So
It's
reduce
trying
the
to-
verdict under your argument also means potentially, according to the defendant, change the crime.
It's not
I'm
necessarily.
trying to, it's hard to think of a
It's-
hypothetical because
right.
it's murder. But
It's
let's
murder.
take it out of the murder for a second. And the defendant, I'm going to stretch your imagination here a little bit.
Okay.
He goes to trial on assault and battery by means of a dangerous weapon.
Right.
Somehow, again, 33E review applies, pretend,
Okay, I'm going to.
and they reduce it.
Okay.
In my mind, what that means is they could reduce it to assault and battery. Assault and battery is a lesser included of assault by means of a dangerous weapon. Could the SJC under 33E review, instead of making it assault and battery, make it trespass? And just say that's fairer. So we're going to reduce it from ABDW to trespass. That's what the defendant is saying they did in this case. They changed it from first-degree murder to a crime that he wasn't indicted for.
And I would point out, could they do that? The whole point of 33E is that it's a capital crime. It's murder, and only murder can the SJC do this. Okay, and murder involves many different types of murder in the first degree, and then it has second degree. The legislature has endowed the SJC with the ability not only to figure out what fits within the evidence, but also what's consonant with justice.
But how can you
And-
hold someone in jail for something they didn't do? The lesser included offense a person did, the jury has found.
Right.
But if it's not a lesser included offense, then no jury has ever found. Now, I understand if they had said it a different way, like, although I don't know if they can do this under the legislation, like, although the penalty for first degree murder is life without the possibility of parole, in our 33E capacity and equitable powers, we will reduce his sentence to life with the possibility of parole, though it is not provided for by the statute. Then they'd just be monkeying with the sentence, not with the
And that's
crime of
what they've
conviction.
done here. I think, honestly, the defendant is overthinking this. And that is why the SJC...
That's what lawyers are paid to do, of course.
And that is why the SJC said over and over and over again in the Brown opinion that the evidence supports the verdicts. The evidence supports the verdicts.
The verdict of what?
The verdict of murder in the first degree.
And what does the, I don't know, minimus say, or the judgment of conviction that you just got on remand, what does it say?
What does the minimus say?
What is the judgment? I assume that with the sentence, there's a conviction, some...
Right. It
Okay.
was remanded for the Superior Court to enter a verdict of murder in the second degree.
Okay,
and
so
sentence
that's the
accordingly.
verdict. You can say they reduced the sentence, but they reduced the crime of conviction.
But, I mean, aren't we really just arguing over what is the power of the SJC
Exactly,
under
Your Honor.
33E?
Yes,
now?
Your Honor. And
Okay, but I just
honestly-
read Paulding, and I struggled to pull out of Paulding what it is that you want me to pull out of Paulding. I mean,
What I'm trying to express to you is that the SJC has spoken on this case. They have the power to do this. And as a practical matter, if in some alternate universe this court rules in favor of my brother and his client, the first thing I am going to do is take this up to the SJC and argue exactly what I argued 7 years ago, have them review it
Yes, of course you
exactly
will.
as they did
That's what you're
7
supposed to
years
do.
ago.
and then he'll try to take it to
Exactly.
the U.S. Supreme Court if we were in that
gonna
alternate
go through
universe to
this
do what we did
all
and see if they think the federal
over
law supervenes it. I mean,
again.
we understand where you are, counsel. I mean, to make an argument to us, though, which I totally understand, which is you have to follow the SJC, that only gets me partway there. I think I'm bound by the decisions of the United States Supreme Court. Now, if the SJC has addressed the issue directly,
They have.
right, that I think
They've addressed
have.
they've addressed the constitutional issue?
In Shepard and in Martin, they did.
Yeah, I think she's right.
They have. And I am
Maybe not every
trying
iteration of
to say that, Your Honor. We have been dealing with this for 15 years. And I am sorry if I sound frustrated here, but we have a victim's family that has been dealing with this for 15 years. This defendant has already received due consideration from this judicial system. They had their verdict reduced to second degree, and not only that, the Superior Court ran those sentences concurrent rather than consecutive, as if one of these brothers' lives did not matter, okay? That is why I'm here saying that I will take this back up to the SJC and have them rule exactly the same way. This defendant has received due consideration from this court.
Do you think the rule that you get the benefit of a change of law while your case is on appeal, do you think that's a constitutionally grounded rule?
I don't, it depends on what was changed, Your Honor. And in this case, where there was a substantive change in the law, where the SJC has specifically ruled for a reason that that law is constitutional as it was before and as it is now, then they have the prerogative to do whatever they want. It's another issue if they're just interpreting that law or...
You mean do whatever they want if they're reducing?
Exactly. Obviously, they can't...
They've got restrictions under federal law in what they do, and that's really what
Absolutely. There is ex
your
post
brother
fac-
is arguing, is that they've supervened some sort of constitutional restriction in the way that they did this under 33E.
And there's nothing in the federal law that supports that. And that is why the United States Supreme Court never took this up on certiorari.
You don't know why they didn't take it up on certiorari.
Your Honor, I've read the briefs. I've included the briefs
You're
in my
talking
record
to a few
appendix.
people who know a lot about how certiorari is and is not granted. You don't know. You don't know why it was done, and that argument is not strong.
Well, I've read the briefs. I'm assuming that they read the briefs.
Sure.
They grant
but
1% of the
they
cases.
take 80 cases a year.
Yeah.
If they thought it was important, they would have taken it up. If they thought there was an issue, they would have taken it up. I understand that Teague is saying you shouldn't take anything from that. But let's be honest, the issue
take
is
anything.
raised. The issue is raised.
Well, all right. You can't take anything from a denial of
Well,
certiorari.
the issue is raised, and they didn't bother to take it up. So
I agree with
here
that.
I am asking this court to follow the directive of the SJC here, which specifically reviewed this case top to bottom and decided we are not applying the new rule for felony murder retroactively, and we are not applying it to this case because it would not be fair to the Commonwealth who had tried this case under the old rule of felony murder. They may have tried it differently. We may have asked for a manslaughter instruction. There are other things we would have done. It is not fair. Instead, they decided to give this defendant as much consideration as they could, given the facts of the case, giving him a second-degree murder verdict. He's now eligible for parole on those murder convictions because they're now concurrent by this October for 2 lives that he knew that he had a part in taking. And so this defendant has received due consideration from this judicial system. We would ask this court to simply affirm the resentencing of the Superior Court here. If there's no further questions, I will rest on my brief.
Well, your time is up anyway. Thank you very much.
Thank you.
The case is submitted.
It's a very interesting problem.
The next matter we will hear is number 22592, Commonwealth versus PENA-LARA. We will hear first from Attorney Hartley.
Good morning, and may it please the court. Brooke Hartley for the Commonwealth. This court should reverse the judge's order where the judge erred in dismissing the case for the Commonwealth's failure to comply with an improper discovery order that would result in revealing the identity of the confidential informant.
Commonwealth, I'm sorry to interrupt you so quickly.
That's
but
okay.
I am really. But I have a procedural type question. On page 123 and 124 of your appendix, and I'll quote, it says, "The Commonwealth has regularly coordinated with members of the Boston Police Department who have been steadfast in their unwillingness to provide the ordered information." Am I to take from that that they have refused to provide it to the district attorney's office as well?
That's right, Your Honor.
So let me ask you, and this is where we get to a problem I have. How can you comply with your Rule 14 discovery obligations of providing exculpatory evidence if they refuse to give it to you?
So, Your Honor, I think in any other context, it would be a problem. In the context of a confidential informant, where we're not talking about exculpatory evidence here, we're talking about...
How do you know that? For all you know, and again, I am not besmirching the police. However, for all the Commonwealth knows, this police officer made the entire thing up. There is no confidential informant. And if you knew that, you would have to provide it. You don't know that, because they refuse to give you anything.
I understand Your Honor's question. I think there's a mechanism to deal with that exact problem.
What's that?
And that would be if the defendant were challenging that all of this was made up, that none of this was true, then the defendant would assert.
The defendant doesn't have to raise anything. You have an obligation to provide exculpatory evidence. You don't know whether it's exculpatory or not, because the police are refusing to provide it to you with a relevant piece of evidence because you want to use it. You have affirmatively said, we want to use the information about the informant at a motion to suppress. But you don't know anything.
So I think especially in this case, Your Honor's concern is not particularly relevant where the information related to these controlled buys, related to the informant's interaction with the defendant, is not necessary at trial to prove the Commonwealth's case. And that is evidenced by the fact that the Commonwealth didn't charge
Does that
those
mean it's
controlled
not
buys.
exculpatory even if it's relevant to the motion to suppress? I don't know the answer. I'm just asking.
I'm sorry, can you repeat the question, Your Honor?
Does that mean that the information being asked for is not exculpatory because it has
think
nothing
so.
to do with trial?
I think so, Your Honor.
Even though it might be relevant to defending against arguments of the Commonwealth on a motion to suppress?
Yes, I think that is the
So
Commonwealth's
exculpatory
answer.
has to do with trial, not with an argument about evidence.
Well, and there's a remedy for that in the law. If the defendant, again, I understand Your Honor's point, but if...
I have to follow up on Justice Englander, because
Yes.
I don't think that's accurate at all. Your officer takes the stand at a motion to suppress hearing, and he says, I received information from a confidential informant, and he goes through the controlled buy. You're saying that if that was all made up, he makes it up, that's not exculpatory.
So
How is that possible?
because it will have no implications whatsoever on the defendant being convicted at trial.
So you're not going to use that information. So why are you contesting it at the motion to suppress? If you're not
So-
going to use it in the prosecution, you can just say, fine, suppress it. Whatever, just take all this stuff off the table.
No, that's not.
Oh, not if it's exculpatory. Okay, I see. Okay, I'm
Not what
sorry.
they're saying, yeah. But you have taken the position that you are going to rely on the reliability of the CI for purposes of the motion to suppress, right?
So I think the trial prosecutor below said that this is what I'm going to use in the hearing. I'm going to use this as part of the reason for the stop. However, if you look at the facts here, it was not necessary for the Commonwealth to prove
I
its case.
agree with that, but
you
I
made
don't,
it necessary.
yeah, I don't understand. I have to say, I don't understand a lot of things about this case. I really don't. And that, I think, is front and center.
So
Why
I think-
is it that the Commonwealth said that? Why is it that the Commonwealth is insisting on that? Because it seems to me there's a way for you to make this problem go away. And instead, you just kept saying, no, we're, leaving us in this position where, Justice Wentland said, here are a couple of ways that you can figure out whether this is really important. And the Commonwealth basically said, nah, we're not going to do that. Or you could have done what we just talked about. You could have said, you know what, we've rethought this, and we're not going to rely on the confidential informant. We think we have enough based solely on the officer's testimony that he observed the controlled buy.
The hand-to-hand, the hand-to-hand,
Yeah, not the controlled by.
not the controlled
No,
by.
the controlled buy.
Well, not the controlled by.
You don't need the CI. The officer handed the guy money for drugs, frisked him, watched him interact with this person. He came back, and there were drugs and no money. He can testify to that. You don't need a CI or his reliability or anything else.
That's true, but I think
You must
Judge D'Angelo,
think
you
it's
don't
not
even need
enough.
you don't even need the controlled buys in this case.
Yes, but you've never said that.
I
You-
understand that at below, the Commonwealth said that we were going to rely on this as part of the reason for reasonable
Sure.
suspicion for the stop.
Do you
I
know
think-
anything about why a memorandum about this, first announcing that there was a controlled buy, was simply handed to defense counsel a year and a half after the crime?
So my
And what is that
understanding-
memorandum? It's not an affidavit. What is it?
So it was a Form 26. My understanding is that was written in preparation for a motion to suppress, which at that point was forthcoming.
Is
We
there a
thought.
police report that's contemporaneous to the controlled buy that exists and has been provided?
There is a police report that's contemporaneous to the control, that happened after the arrest, and the controlled buy happened within 72 hours of the arrest. So
And that's in the
No,
police
But
report?
here's my question.
Police report, yes.
Ms. Hartley, my question is different. Is there, and I would think it would be the practice to do this, is there a contemporaneous police report from 18 months before that exists in the file that says this controlled buy occurred?
Your Honor, I don't believe so, but I don't have that information because the Commonwealth.
Not in the record.
It's not in the record,
In the
yes.
record, the controlled by is only through that memorandum of May something 2016.
That's right.
Okay, so
That's
now let's go back to some of the stuff in this case.
Sure.
The defendant learns about that, he files the motion for discovery. Within his motion, he suggests that a protective order could be placed on him.
Mm-hmm.
Now, your obligation under Whitfield, the most recent SJC case, is that once the defendant makes the discovery request, you have to affirmatively properly assert the confidential informant privilege. What do we do with the protective order regarding that assertion?
Yes, Your Honor. So Whitfield, I think, says that it's within the motion judge's discretion to order, these remedial measures, these compromises, like a protective order. But they have to be consistent with the legal principles. And to say that the Commonwealth could not have met its burden, because with some sort of compromise like a protective order, it would then be able to protect the identity of the CI, is turning the Bonnet test upside down.
Well, I agree, except you have to show. You can't just say, we assert the privilege. That's not enough. Bonnet says you have to show that the identity is necessary, or the precluding giving the identity is for his safety. That's sort of your showing. So in this case, they've already said, give us a protective order. So don't you have to make a showing that that is not enough to protect his identity, to properly assert the privilege?
Well, Your Honor, I would first mention that, yes, it's the safety of the confidential informant that's at issue, but it's also a question of whether this disclosure would impede law enforcement in their efforts in general. So
Is that in Bonnet?
yeah, that's in Bonnet, yes.
Okay.
And the reason for that is the whole public interest question here, which is a huge part of the test. I mean, we have to consider the safety, but we also have to consider the chilling effect that any type of disclosure will have on a confidential informant.
Does the I'm sorry.
That's not the law. There are clear suggestions in law. We have cases where material has been given only to the lawyer and can't be shared with the defendant. Now, I understand why maybe in some cases, maybe lots of them, maybe a tiny number of them, that may not be adequate. Maybe there's something you know about the relationship between the lawyer and the client that makes you mistrust an order like that. Maybe there's, right, I have no idea. But those have been upheld. Those are fine. And this had a protective order. It was not being turned over to the defendant, but only to the lawyer. Are you saying that that's never an adequate protective device?
I'm not saying it's never an
So why
adequate
isn't it
protective
here? Because you
device.
didn't tell us, or the court below, anything about that protective order. You just didn't turn anything over.
So I think the answer is twofold. First of all, I perhaps disagree with Your Honor that the question is just about the safety of the confidential informant. I think if you look at Gandia, which is the
Whatever
case
it's
that came
about,
out-
we've upheld protective orders like this.
Can I stop this for a moment? Because this judge is just trying to catch up. Are there cases that say the protective order is sufficient, and does the Commonwealth accept the notion that a protective order is sufficient in the context of a CI?
At times it can be. If you look at Whitfield.
There are cases
where the protective order
where
is
somebody
sufficient.
said, hey, there's a protective order, and that's enough.
I don't have a case that says.
Yeah, neither do I. And I have a serious issue as I was reading about the offer of protective orders as to whether the Commonwealth is going to think that's good enough, given the nature of relationships between lawyers and defendants in this context. So I had a real question in my mind as to whether that case law existed or not.
And I think if you look at Whitfield, this might answer Justice Rubin's question in part. The defense attorney had also suggested a protective order, and the court still found that the Commonwealth had asserted its privilege and moved on to the next step of the test.
Wait, but you just said sometimes you accept protective orders, sometimes not.
So-
And you have not told any court why the protective order in this case is inadequate. I'm not saying it's adequate, I have no idea, but you haven't told us what's inadequate about it.
Your Honor, I may have misspoke. So I don't think a protective order comes in at the first step where it's the Commonwealth's burden to assert the privilege. I think the court must go through the Bonnet test, which requires, number one, the Commonwealth to assert the privilege, and then the burden shifts to the defendant to prove that there is a trial defense, and then we do the balancing test.
Let me ask you about that burden that the Commonwealth has, and I frankly don't think the case law has gone into great lengths about what that burden is. It seems like you think, and perhaps fairly, that you just have to assert the privilege and say, if we give up the name, the CI's life is in jeopardy, and that's it.
I don't think that's it, Your
So
Honor.
what did you do in this case to say basically more than that?
So, well, first of all, in this case, if you look at the motion judge's order, she didn't even consider this. She moved on to the second step. There's really no findings in the record
Great.
as to whether, the Commonwealth properly asserted the privilege. I think she implicitly found that the Commonwealth did, since she moved on to the next step. But in this case, again, this isn't in the record, but the information that was ordered could be used to cross-reference dates of the controlled purchases with other dates, communications, or memory of the
That in
defendant.
the Commonwealth's submission to the trial court?
Yes, that was in the Commonwealth's,
Cross-referencing dates and so forth?
yes, I believe that was in our opposition to the discovery motion and in our motion to reconsider.
Okay.
What about the suggestion by Justice Wentland that you submit the documents for in-camera review to the judge as sort of a, I mean, the way I would understand that could work is the Commonwealth submits them to the judge, says, look, we'll let you look at them as long as you don't order their production without our opportunity to intervene and do something different. Why didn't the Commonwealth, do that?
So first of all, I very much disagree with the defendant that Justice Wentland, in her denial of the Commonwealth's 211-3, required the Commonwealth to do anything.
She made suggestions.
She made
didn't
suggestions. She
require
didn't
anything.
review the merits, and she cites Rodriguez and Platt, which are both cases where the Commonwealth did appeal the denial of a 211-3, and the merits are not addressed at all in those cases. So, and I think it goes back to my point about going through, the law requires the court to go through the steps of the test. And then, if the judge...
But I didn't hear an answer to my question yet. And if you're getting there, you're going to have to draw the link, because I don't see how you're getting there, okay? Why didn't the Commonwealth offer it in camera before they just sort of said, nah, we're done?
Because that shifts the burden and is not what is required by the test. Once we go through and find that this information does need to be disclosed, then we can apply those compromises and try to protect the informant's safety,
There was a finding that it needed to be disclosed. There was an appeal by the Commonwealth of that to the single justice, and the single justice didn't say, you know what, I think that they were wrong. I think the lower court was wrong in saying it needed to be disclosed. The single justice said, I'm really not taking a position on that yet. Why don't you offer it in camera?
Well, that's right. I think that the issue here is that the Commonwealth takes issue with the judge's order, and for that reason, it appeals, because we want the judge to go through the steps of Bonnet. And I know it seems like the Commonwealth is, turning up its nose at the court, but I think the reason why we took this appeal in the first place was that we had found that and this is not part of the record, but time and time again, the court was not going through the steps of Bonnet.
Okay, so the error that you say occurred, and I'm sorry to draw this past the red light, but
all right.
the error that you say occurred is the judge didn't go through the steps of Bonnet the way the judge was supposed to. And the particular thing that the judge didn't do was determine whether it was really necessary to the defendant's case. Is that right?
To determine whether it was necessary to a trial defense. And the law is clear that articulating that you may need this for a motion to suppress is not sufficient.
The law
wait.
is clear on that?
Yes, Your Honor.
Which
Yes.
case do you cite for that? Because, boy, what you just articulated, that really helps me, but I didn't get that out of the briefs. And it also doesn't strike me as intuitively obvious that would be the law.
So I think if you look at Whitfield, that was one of the defendant's reasons for needing the information, saying that it was relevant to a motion to suppress. The court rejected that, said that is not sufficient. And
Really?
Whoa.
In Whitfield,
I agree
which I
with
read
you.
last night,
I
learned that
agree
from?
it might say that, but this is different. This is not an affidavit for a search warrant. You're going to put
Correct.
the officer on the witness stand. His credibility is at issue when he takes the witness stand.
Absolutely.
But the defendant can't cross-examine him about certain things that go to his credibility.
So the defendant can file a motion to suppress based on Aguilar-Spinelli. And if the Commonwealth...
No, Aguilar-Spinelli talks about search warrants. Franks v. Delaware and the other one I'm forgetting begins with an A. Anyway, that deals with search warrants. This is where this is at a motion to suppress level, where you're putting the officer on the stand. And he's going to be allowed to testify to some things that you want him to testify to, but the defense isn't going to be able to cross-examine him about the same things. He can get up there and say, X told me Y and Z, or CI tells me X, Y, and Z about this controlled by. He can testify to that. But when defense wants to ask him about that, you're going to object and say, no, confidential informant privilege. That's how it's going to play out.
So can we just...
That's
I'm sorry.
Whitfield.
Now we're going to go ahead if there are questions.
Yeah, I'm reading from Whitfield.
Mm-hmm.
And there's a sentence in here A distinction exists between a demand for disclosure for pretrial purposes, where the issue is probable cause for arrest or a search, and demand for disclosure at trial. While the standards of disclosure for pretrial purposes are more demanding, that doesn't say you don't get it. It says they're more demanding.
No,
What am I
and that's
missing?
absolutely true. I don't think I'm not arguing that the defendant will never get this pretrial. I'm arguing that the defendant still has to assert a defense that is relevant to a trial defense. The defendant can't say that this is something that is relevant to a motion to suppress. And I believe the line in Whitfield is, the court rejected the defendant and the judge's assertion that the information was essential for defense counsel preparation for a zealous defense regarding his client's anticipated motion to suppress.
What are you reading from now? Not Whitfield.
I believe that's in Whitfield.
Read it again then.
Essential for the defense counsel's preparation for a zealous defense regarding his client's anticipated motion to suppress.
Is not enough.
Yes.
What you think Whitfield
Yes,
says.
if I can submit a 16L if that is not from Whitfield, but I have it written down here that it is. And Your Honor has it right in front of
Can
you.
I ask
so.
you a question while Justice Englander looks at Whitfield? And this is comes out of the first question that Justice D'Angelo asked you. Your position, and the position of the attorney below, I don't know if that's you or not, but I don't really care, have taken the position that literally nothing that was ordered here can be disclosed.
That's right.
So this includes this, let's say there's something to where the controlled buy took place or sight lines about the controlled buy. Okay, so I have no idea, but maybe. So your position is that every statement made by the confidential informant, every statement must be withheld.
That's right. In this case, I think.
But you don't know what the statements are.
I
Can a
understand.
lawyer file something in court asserting every statement that you have ordered turned over, Your Honor, is protected by the privilege, and therefore we will defy your order? But I don't know what the statements are. Can a lawyer file that?
So I think when you look at all of the information that was requested here, or that was ordered to be turned over, the requested statements, the statements, information about the controlled buy, including date, time, location, information regarding the informant's motive to lie. When you look at that information.
How about that? Yes, we knocked down a charge against him. Yeah, we gave him $1,000. Yeah, we let him keep the drugs. Whatever it is the Commonwealth might have done, how can that be privileged? We promised him he would not be convicted, he would not be prosecuted for these 3 outstanding, these promises are made routinely. You don't know if any promises were made, do you?
No, Your Honor, I don't know. And I
Okay,
think
so how?
routinely these things are also protected by the privilege and not turned over.
I was going to ask as a follow-up before Justice Rubin. You told me, and I'm going to accept what you say, that in the opposition to the defendant's motion for discovery, the line DA who wrote it said that the dates and all that would disclose the name. How does that prosecutor know that? Doesn't know the name, doesn't know anything about the dates of the buys, doesn't know the site. He doesn't know or she doesn't know anything, but makes that assertion in in an opposition filed with the court. How is that proper?
Well, Your Honor, I think regardless of whether the Commonwealth knows it, and I understand Your Honor's concern here, if whatever the dates are, whatever the statements are, if they're cross-referenced with, the communications or memory of the defendant, that is very probably.
What if it was one controlled buy? What if that was the only one he's ever done? How can they cross-reference if there's only one? He made, she, whoever the line prosecutor was, made assertions in that motion that he or she has no idea whether they're true or not. Could be one controlled buy. We don't know. So there couldn't be any cross-referencing, but they said that in the motion. And you're saying that that's
told
a
that by the
proper
police officer.
assertion of the CI privilege when he or she doesn't know it. It seems to me when we talk about steps that the SJC is given to assert a privilege, and they use the word proper, has to properly assert the privilege. How can that be proper?
I understand Your Honor's concern, and I would bring it back to this case, which is perhaps different than other cases where you have this issue, where the controlled buys are not charged. Where
Statements made by the informant. That's what my question was. It wasn't about the controlled buy. How do you know there isn't an exculpatory statement somewhere in there? His license plate was this, although I got to tell you, it was pretty far away, and I'm totally not sure.
So
Right? Or I think it's a guy, like, you don't know what he
I
said.
don't know what the statements are. I don't know what.
But you can
what-
imagine some of them being equivocal or
Sure.
exculpatory.
And I think in this case, that's what I was trying to bring it back to this case. It goes back to what Justice Englander mentioned at the beginning here. None of this is going to be relevant to a trial defense.
But it is relevant to the motion to suppress the very evidence that will be used at the trial, so I count that.
So I understand that, Your Honor, and I think also the Commonwealth can satisfy its burden at the motion to suppress, or the Commonwealth can prove that there was reasonable suspicion for the stop at the motion to the suppress hearing in this case without that information.
Right, but you didn't say that.
If you said we're not going to turn any of this over or use it for anything, okay.
So if you look at Spinelli, the
Although
court
it could
said
be
that the
something else.
information, I realize I'm out of time, and
No,
there'll be one
long,
last
but
point
it's,
before, unless the court
and
has
we'll
other
give you
questions.
additional time.
If
should
the
you.
informant's tip does not satisfy each aspect of the Aguilar test, other allegations that corroborate the information could support a finding of probable cause. And that can be applied here. The officer witnessed a hand-to-hand transaction, and that is what is charged here, and that is what.
Well, if you just said that's the only evidence we have, we happen to be surveilling, we're not going to tell you why or whatever, we happen to be looking, and we saw this thing
Certainly, it
happen.
would have been much easier.
But I assume it wouldn't have
Perhaps.
been successful, or you wouldn't be doing this.
I disagree, Your Honor. I think it would have been
Well,
successful.
you
but-
said, all right.
Can I, in answer to what Judge D'Angelo was asking, presumably, prosecutor has a conversation with a police officer in which they say, this is what you've been told you have to produce. And the police officer says, if I produce that, it's gonna provide his name. Because they're gonna know because of X, Y, and Z. Presumably, that's why the prosecutor goes back and says, can't do that.
That's right, yes.
That's why the police officer does.
No, that's why the prosecutor
And Your Honor, I
comes
think
back and
probably
writes
there
what
was
they
that
write.
conversation here. It's not part of the record, and I think the Commonwealth Certificate of Noncompliance here was more of an explanation to the court as to what was going on, rather
That's why
than.
I asked you the first question. I went to that, and you said it's fair from that to infer that the Commonwealth, the DA's office, I won't say, didn't know anything about what the police officer.
I think I have to say that because it's not in the record, and
Right.
I don't know it. So I think that's kind of
So
what we're stuck
Justice
with on
Englander's
appeal.
question is, you have no idea.
That's
That
right.
wasn't my question. Don't change the question.
It's presumably.
I'm sorry, that wasn't my question.
You said presumably, and you said yes. You don't know that.
No, I don't know that. That's right. That's right, Your Honor.
We have elapsed rather a lot of time, and we really appreciate your willingness to
Thank you, Your Honor.
stay and answer extra questions. It's very helpful to us. Obviously, it's an unusual case. We will hear next from Attorney Lown.
Thank you. Zachary Lam from Mr. PENA-LARA. So if the court tells you to do something, you do it. If the court tells me, I was the trial lawyer on this case, and if the court tells me that I have to abide by a protective order, I have to abide by the protective order. I don't get to say, you know what, I really don't like that protective order. I'm going to show this information to my client anyway. I don't know what would happen to me in that situation.
You know, I hear what you're saying, and I think that's perfectly legitimate, a response. But the problem that may arise is that you now have information, and let's take it out of the context of you. A defense lawyer now has information, and they've got other clients, okay? And they now have certain information that may cause them to advise their clients in particular ways where they don't think they're disclosing what they know, but it's causing them to change the advice that they give. And that I think could be a very legitimate concern of the Commonwealth.
So, Your Honor, I would cite, you asked earlier about cases with regards to a protective order. One of the cases I mentioned in my 16L letter was a recent decision of yours in Hendron, and a citation there is Rodriguez, which is 484 Mass 1047, and another citation there is Holiday, which is 450 Mass 794.
And what does that case say about the use of protective orders?
it says that the protective order is a valid method to protect a CI's identity when seeking information other than a CI's name. And then Holiday goes on to say, is cited for the proposition that they assume that defense attorneys uphold their duty to comply with rules and orders, including protective orders under Rule 14. And I've had, maybe I'm getting a little far afield here, but I've had hypothetical scenarios where I've had clients and then their case, in some way interact with someone else in a manner that you kind of alluded to.
Yeah.
In a different case.
But we need to
And
take
as
it out
soon
of
as
the
that
context.
happens-
We need to take it out of the context of you.
Okay.
Because, you know, I'm willing to give you every benefit of the doubt. I still could see the Commonwealth questioning the vitality of that in certain
They
circumstances.
should certainly raise it before the judge and say this is inadequate
And
before
that
not
is
complying
precisely
with the
what they
order,
did not
right?
do, Your Honor, because in this case, the order was effectively narrowed by the single justice, as I argued in my brief. After we requested this information, the judge saw something here that was at least enough to raise eyebrows to say, okay, some further information is necessary.
Well, I don't know if that's accurate. I don't know if it raised any eyebrows. What it may have been is the government said they're going to use some of that information, and the judge in balance said, if you're going to use some of it, then you have to give something to the defense to have an effective cross-examination. That could be. And what the prosecutor said in her argument is very accurate. Justice Wendelin didn't make an order that you could do these things. She gave suggestions. And frankly, there's case law that says the single justice, we're not bound by it, has no precedential value. So I don't think we should give too much, with all due respect to our former colleague in Justice Wendelin, we really can't talk that much about the single justice order, right? I mean, you agree with that?
So I think that once we got to that, what Whitfield says is that a judge is to make a fact-specific inquiry based on the record before it and based on the procedural posture of the case. And when the case was remanded or came back to the trial court, at that point the judge had to make a decision as to what would have been necessary, first of all, for disclosure, as well as to ensure that the order didn't, in fact, reveal anything about the informant. And the Commonwealth said, we're not going to participate in that process. We're not going to follow your order. We're not going to submit this with a protective order, notwithstanding the fact that I think Justice DeAngelo pointed out that they don't actually know what the information is, and therefore precluded that process from even taking place.
Let's talk about the remedy now, because I do have an issue with that. Was dismissal the appropriate remedy? I understand that the Commonwealth, maybe with good reason, dug their heels in and said, we're not going to provide it. But a judge is supposed to look at appropriate remedies. Was dismissal, which the cases have said is the most drastic remedy, was that the appropriate remedy?
I think it was an appropriate remedy, and this actually dovetails into another point that I wanted to make, which was that the Commonwealth has essentially taken the position that this information is never, the way I read their position, is that it's never disclosed pretrial. It's never relevant just to a motion to suppress, even though they're putting it at issue. That's how I understand their position. What I want to say is that I disagree with that. I think it is relevant, and I also think they made it relevant. And two, it is also relevant to trial, because the police officer is claiming to have seen interaction on Lyford Street, which was where that supposed hand-to-hand took place. And that police officer is going to testify at trial, and his credibility is going to be the central issue. His credibility as to what he saw on Lyford Street with this alleged transaction, even his credibility as to what he found on the defendant. So if there are any discrepancies, any attacks to be made, any motive, any bias.
I think you could put in that he made up a confidential informant that has nothing to do with the trial.
I think that if there was some showing of bias or some showing of motive to lie, whatever that may be, or if the police officer in the
It
investigation.
seems to me to be quite a stretch. The police officer's going to testify about what he saw at the time of the event, and you're going to cross-examine him about a confidential informant that nobody knows about and hasn't been introduced at all. That seems to me to be a real stretch.
Wait,
Well, Your Honor, if a police officer fabricated, and I'm not saying that's necessarily what happened here, but I'm going with your hypothetical. If a police officer fabricated that just prior to what he saw, even though right now the jury doesn't know about it, but I know about it, and a police officer fabricated for whatever reason.
Well, it
wants to
wasn't
go
just
after this-
prior, it was days before, as I
Days
understood.
before, because he wants to go after this defendant because
All right,
he's.
okay, I understand your argument.
can I ask a question about the remedy? So, of course, it's true that the harshest remedy is dismissal of the complaint. But the Commonwealth said, we intend to use this at the motion to suppress. The judge said, okay, then turn over this with a protective order. The Commonwealth didn't say that protective order is inadequate. They didn't say, no, could you look at it in camera? They didn't say, okay, we won't rely on any of this. I'm not sure if that's good enough, but they didn't say that. What they said was, no, we refuse. So it seems to me that arguably, or at least within the scope of someone's discretion would be to say, a judge's discretion, would be to say, then I am going to allow any motion to suppress. So you're not going to have this evidence. So you're not going to have a case. So I'm dismissing it. Not because dismissal is the first step of the analysis, but because if you can't fairly litigate the motion to suppress, and if the evidence that you want to have suppressed is the whole case, what remedy, what should she do?
I don't know what option is left. I mean, I think suppression and.
Well, let me give you a suggestion of what could have been. Before you knew about that May 2019, I think it is, memo, what you had was not a controlled buy, what you had was a hand-to-hand sale, allegedly.
Right.
You go forward on the motion to suppress, the judge says, if they're not going to provide anything about the CI, you can't introduce anything about the alleged control buy, you can't introduce anything about what that informant says. All you can do is testify as to what you supposedly saw during the hand-to-hand sale. Why wouldn't that be an appropriate remedy? It excludes all the information that the government refuses to provide and anything that you would need as far as reliability and knowledge of the CI.
The reason why that wouldn't be an appropriate remedy is because, I'll quote from Hendren.
Well, Hendren, I'm pretty familiar with it.
Okay.
That was a situation where the judge made a finding that without the evidence that if the trial judge excluded, the Commonwealth would have no evidence to present at a motion.
But isn't that this case? Because didn't they find the license plate of the car to observe because they were given it by the informant? Isn't that fruit of this same poisonous tree?
They're claiming that that's what led them to the informant, that's what led them to the defendant.
And to watch.
And to watch.
So why can't they just introduce evidence about what he saw?
Well, so one, they insisted that they weren't going to do that. But
Well, I don't know if they insisted that because the judge never gave that as a potential remedy.
So the reason why I think goes to what came out of Hendren, where the court essentially rejected that claim and said, even though the Commonwealth claimed it did not seek to introduce any evidence at trial of the informant's involvement leading up to the arrest, nonetheless, the court ordered informant-based discovery, found that informant-based discovery was relevant because it went to the investigating officers' credibility, which would be a central issue at trial. And the quote from Hendren was, they rejected this argument.
This is not a published opinion, right?
No.
Okay, so that would be useful
So in other words,
for me to know that.
okay, I should have said that up front.
Yeah.
Yeah.
We need
But
to-
I think that even though it's not a published opinion, I find the logic persuasive in that, as I said, it has its own exculpatory value. If they did make all this information up wholesale or there's any inaccuracy, like what one of the justices alluded to. Well, we didn't get to see the license plate exactly, or, you know, I'm not sure if it was actually a Dominican male selling heroin. If any of that information is inaccurate or there's any discrepancies there, then it's relevant for trial. And the relevancy doesn't have to be admissible.
How is that relevant for trial if they don't admit it? Again, if the Commonwealth, we're going so far afield, but if at trial the Commonwealth says, did you go to such and such a street, whatever the street was, on that day? Yes, I did. And that's all they ask. Then it all becomes what's the officer's observations when he's on that street. I saw the guy come out of the building, I saw them exchange something, and then we searched them, and lo and behold, we found drugs. That doesn't introduce anything about why the officer is there, which is really not relevant. What's relevant is the hand-to-hand sale, because that's what he's on trial for, at least at trial. I think you might be onto something that it's relevant for the motion to suppress, because they, for some reason, which none of us can seem to figure out, they made it relevant, because they said, oh no, we're going to introduce that stuff. If they had said, we're not going to introduce that stuff, you would have been, I think you said you were the trial, you would have said, okay, I'll file the motion to suppress, we'll go forward on the hand-to-hand sale, which is a close case, maybe.
I'm sorry.
What's the best case for me to read that's going to establish, contrary to your opponent's argument, that the CI law applies when you want information for motions to suppress as opposed to for trial? That you can overcome the confidential informant privilege in the context of motions to suppress?
So I think I cited a few cases in my brief. One, I believe, was a probation surrender case. I think it was Kelsey. I'll have to find it. I can submit that in I don't want to.
That's okay. So you think that I can find them in the brief? I'll take a look.
Yes. But
I mean, Whitfield doesn't seem to say what they're saying anyway. I mean, Whitfield seems to suggest that in the pretrial context, you can overcome the confidential informant privilege. Maybe I'm reading it wrong.
I think that you wouldn't have a higher and lower standard if it wasn't permissible.
But you have a burden before that.
I'm sorry?
You have a burden before that in order for the privilege to be divulged. And your burden is, unfortunately for you, kind of like Frank's. You have to make a showing that there's been a misrepresentation or something like that from, in most cases, the affiant. In this case, you would have to say, the officer is making up this stuff about the CI, and I have this as my basis, right?
Well, I would take one step back from that, Your Honor, and say that the Commonwealth first has to show that the privilege only applies where it would reveal the identity. And we're in a situation where it wouldn't reveal the identity. They never contested that it would. They never said a protective order was insufficient or any of these other measures. And so they never get to step one. But even if they do...
How can that be? I mean, the order says provide the date on which the transaction took place, the time and the place. I can't imagine anything that wouldn't... I can't imagine how that would not give the defendant the knowledge of who it was he was dealing with at that time and place.
It would give potentially the defense attorney that information. It wouldn't give the defendant that information.
Because of the protective order?
Because of the protective order, and because of these other options that the Commonwealth had, which would have been to give information to the judge, for the judge alone to look at. So I don't think they...
That option is only because that's only a precursor to the defense counsel getting the information, right? They're giving it to the judge to try to convince the judge that the information is so obviously going to give up the confidential informant's name and that it's not that important to the defendant, so you shouldn't produce it. That's all. That's...
Okay, your time has expired, although having gone 12 minutes over for the Commonwealth, if there are more questions. All right, thank you very much. Really interesting case, both of you, and well argued. Thank you very much. We are going to take our traditional mid-morning break, and we will return for the final three cases in 10 to 15 minutes.
Court is out of recess.
willful ignorance.
Court is open, please be seated.
Good morning. Welcome back. Our next case is, it is partially impounded, and I don't know if that covers the name of the appellant, but I am going to not say the name of the appellant. You all will know better what the scope of the impoundment is. So why don't we just say it's number 23-533, Appellant versus Commonwealth of Massachusetts, and we will hear first from Attorney Stiles.
Good afternoon, Your Honors, and may it please the Court. My name is Attorney Ethan Stiles, and I represent the appellant, the petitioner in this case, in the Section 9 SDP appeal. Let's see, and one of the most difficult tasks a court undertakes is to try and predict future behavior. And in this particular case, it is especially difficult when you're asking what a 71-year-old man might do if he were released based on offenses which occurred half a lifetime ago. And we have raised 4 issues which suggest that in this case that there was unfairness in those proceedings. We start with jury instructions that were lacking balance to anything from those to label static 99 labels that weren't given proper context, and offenses that were wrongly deemed sex offenses, and finally a closing argument which did misstate which dismayed the law and invited the jury to make a commitment determination based on factors that were inappropriate. So when it comes to we have a request here for jury instructions that were made, and my predecessor asked the court for some balance in the jury instructions because the instructions that the judge had crafted talked all about what the Commonwealth didn't have to prove and what the jury could consider when finding that that if the petitioner was dangerous, still sexually dangerous. Now he asked for 2 things that essentially asked the judge to say, you may consider the absence of recent sexual behavior in reaching your verdict. You may consider whether circumstances have intervened, such as treatment, age, or some other factors, so that he does not no longer pose a danger due to the lack of the problems that have plagued him in the past. And I'm paraphrasing somewhat.
Can I ask you, counsel, did the judge follow, or are there model jury instructions regarding SDP cases?
There have none issued with the authority of the Supreme Judicial Court which sometimes does. So in that sense, no. There are some model instructions. I believe they're published by the MACLE or another unofficial source. And they tend to be, they're somewhat shorter, but those exist. But in terms of some that a court has issued, no, there's not. Any real model. So essentially it's up to the judge and the parties to take from the statutes of the case law and craft a charge.
So we're going to have to figure out, of course, whether it was an abuse of discretion not to give those requested instructions or an abuse of discretion to give the instructions that were given. That's a high-ish bar, abuse of discretion, but I think we understand your argument about that. I'm very interested in the use of this well above average risk category, and I'm hoping you can.
Now, now the labels we had. Now these are post-George labels. So George acknowledged that there were new labels. That Dr. Hansen has called. You come with these new labels, but those weren't in consideration in George. So now we're dealing with post-George labels. In this court, as I had to show that in unpublished opinions, they said we don't have a problem with those. But in this particular case, the issue here is. If you do not have a proper context for those labels, they invite prejudice because they're subjective. What does above average or well above average mean to you might mean something different to me.
The jury was told 2 things in this case I believe by the expert. One was what the applicable percentage of likely recidivism risk was for that category, which I believe was 17.8% within 5 years. And they were also told what average meant.
I disagree with you in part, Justice Englander, because there was some experts gave the client, the petitioner, a 6, and some gave them a 5. And those correspond to well above average and above average. And well above average was defined as 17 point something, and above average is defined as 12 point something. But we don't have what average was. At least it's not easy to determine what.
Wait, under this thing, average is 12% risk?
No,
above average is 12%.
Yes.
But I thought there was evidence that average was between 5 and 15%.
If it's there, I didn't see it in the.
That was cited by your brother, and so I assumed it was correct. But your brother said that the jury were told average meant between 5 and 15%. I gather it was by a qualified examiner. Perhaps, do the QE reports themselves go into evidence?
I believe, yes, I believe that they would have talked about some statistics, although what the jury may have read in them or whether they refer to them at all is unknown. I mean, all we can say, we assume that the jury did, listen to the testimony, and but we don't know what notes they took, we don't know what they took from it, and if it was in the testimony, the reference may have been fleeting. It's not something that was clearly delineated as it really should have been in order to allow the George.
No, I'm looking at it now.
I'm looking at page 36. The jury was informed.
S9 QE report, page 66 of App, Volume 2, and it says in routine samples of sexual offenders, the average 5-year sexual recidivism rate is between 5 and 15%. Then it says the 5-year recidivism rate is 17.6%, and between 15.8, well, I mean, I'd have to go through, but it is in there. I was going to ask, and maybe I'll ask your brother, how 17.6 can be well above an average that ends at 15, but I'll ask him.
I think it goes to the point that, if you have to sift through the reports in order to find the average, I suggest that that's not enough. I mean, if an expert were to clearly go through it and say, this is the average, this is what I found it to be, then the jury can make their own decision. But we don't have that here. All we may have it buried in the report.
One of the categories of the static 99R average?
I'm sorry, Your Honor?
Is one of the categories average. So we have well above average and above average. Do we also have a category that's average?
I believe so.
Jury told what the number was for average?
I do not believe, not in testimony.
And do you know how many points? This is a 6 is well above average, a 5 is above average. Do you know what numbers are average? Again, your brother may have more.
I want to say between 3 and 4. I haven't looked at the static 99 in a while, but it would be in that. Well, actually, no, I think it's 2 and 3. It is in the static 99, I just haven't looked at it, but okay. I feel that average is between 2 and 3, and 4 and 5 is above average. But that's based on my memory, so don't rely on me 100% on that one. So now, the third argument, I think we've just covered the first two. The third argument is the unadmitted sex offenses. Now, there were 2 offenses from the 1970s, and the QEs called them sex offenses.
Whoa. Where did the QEs call the pipe one a sex offense? I didn't see that in the record at all. You know what I'm talking about. So one is the baseball bat.
Yes.
And another one is the pipe.
Yes.
And I did not, in fact, again, I'm looking at your brother's brief, that the Commonwealth was pretty careful not to call that a sex offense, but to separate it out.
Well, I think the qualified examiner certainly talked about the facts of the case as though it were sex offenses. They
didn't use the word sex offense, though. They talked about it as a violent offense, which it is, and which is relevant, right?
Yeah, I believe so. However, I can't think of obviously, whatever my citations are in the brief for that would have to control. However, nonetheless, the first offense.
But the second one I want to focus on, because the Commonwealth agrees that is not a sexual offense. I thought you said that one of the QEs counted it as a sex offense because they had 5 prior instead of 4.
Certainly talk about it in the same breath, as if he hadn't run off. So I think that you take it as a jury may have taken it as this was a sex offense. But now the first sex offense, the 1974 one, I think that that's a case where, well, obviously did call it a sex offense, although the sex offense was null prost, and we don't have the records really to talk about that since it's so old. And in that sense, there's really no so limited a basis to find it as a sex offense as opposed to a violent offense. That should not have been considered as such.
Isn't there a basis, though, from which one could infer that it's a sex offense that's in the record?
I believe that that the argument was made that because the petitioner grabbed the person's pants, you may consider it a sex offense. However, in this case, the petitioner never admitted that he had any kind of sexual motive for it. He was looking to rob them, and the facts really don't support that claim in the context of a robbery.
Well,
Do you have any idea how we're supposed to construe? As I understand Mackey, it says that for it to be a sex offense or treated as for there to be treated as an offense for which there's a sexual nature, that the sexual aspect has to be proved, admitted, or otherwise established. And I don't know what, it wasn't proved. I don't think it was admitted, because I think the 2016 admission is that he was pulling at the girl's shorts to pull her down. So I don't think it was admitted. What does otherwise established mean?
I think you would have to look at the totality of the evidence, of the facts in that case, and make a determination that it did constitute a sex offense as defined. But the jury was not instructed as how to do that.
What was the jury instructed on this particular subject? Do you remember?
Nothing. They were not given any. I don't recall them giving any instruction on whether, on the language of the otherwise, the catch-all language of Section 1. I don't think they were given any instruction on it.
So, I mean, from the Commonwealth put this in as a sex offense. The QEs identified it as a sex offense. Mackey says has to be proved, admitted, or otherwise established. But here we have a police report that says he knocked me down and then he started to pull my pants off. And he admits to actions which pulled her pants off. Is that enough?
I would say on this fact pattern, no, because he needs control in order to rob her. He's attacked two women. He can't realistically expect that he's able to do anything more than mug them, really, given the circumstances of the offense as described on the facts. So now my last argument deals with the Commonwealth's closing argument, the poison cookie analogy, which I consider could be construed as a dog whistle to the jury, which may invite them to convict on inappropriate considerations. Now it hits the big three of that it trivializes constitutional rights, it misstates principles of law, and it provokes undue bias. Now the point is made is that you have a cookie, there's a 12% chance it's poisonous. Would you eat it? No. You would consider the risk too great. But I consider that the trivialization means that any risk is too great, and I think that is the message that could have been conveyed or at least received by the jury, even if it wasn't objected to.
And the reason for that is because he uses the word poison?
Yes, because essentially no one is going to eat a poison cookie regardless if the risk of death or bodily injury is 1% or 12%. It's, the argument is a wolf in sheep's clothing. And it was...
Well, is it? I mean, the risk here is that if he's released, he's going to spot a woman by the side of the road and decide that he wants to rape her.
I mean, one might...
That's pretty poisonous.
But the point is that that's not the law. The law is he likely to do that under Boucher? And we have to consider that, by what it concerns. Is there any possibility that he might do that? Especially a 71-year-old man might do that, which I think is somewhat difficult.
The QEs say that the risk is for someone in his and his risk category is 17% within 5 years.
So if that's all he said, that's something they consider, but he doesn't. He goes on to make an analogy that says, any risk is too great, you must keep him inside. You cannot let him go. And I think that is the impropriety and the danger with these arguments like this, where the analogy is not appropriate, is that you essentially invite the jury to do something that they shouldn't do.
Do you have any case law that says if a prosecutor said something exactly like that about any risk?
I don't have anything directly on point as to that issue, as to that question.
All right, your time has expired. If there are no further questions, very good argument. Thank you, very helpful to us. And we will hear now from Attorney Mansfield.
Good morning. May it please the court, Brian Mansfield for the Commonwealth. As stated, this case presents 4 issues, none of which either individually or collectively warrants the reversal of the verdict of sexually dangerous person that was delivered by the jury below. The first argument was the jury instructions. They were given consistent with the law. The Hill case long ago said the Commonwealth need not prove contemporaneous or recent sexual offending because they're in a secure facility and the sexually aggressive impulses are unlikely to have an outlet in such a secure facility. So therefore, the instructions all were well within the law. The judge clearly instructed.
Let me ask you about that specific quote that you just made. If a person does do acts within the facility that are sexual in nature, the Commonwealth can introduce those.
Yes.
So why isn't it fair for a judge to instruct it both ways?
Because the focus is on that the Commonwealth doesn't have to. The petitioner's attorney was certainly allowed and certainly did argue that the jury should take into consideration that he didn't do anything, and then it had been over 20 years since the appellant had actually committed a sex offense.
So it's fair to say that a jury can consider the fact that a person did not commit any sex offenses, crimes, et cetera, within the facility.
Correct. And in particular in this case, where the jury was instructed over 23 times that what they're looking at is now presently at the current time that he is sexually dangerous. So the instructions certainly covered the waterfront as far as what the courts have allowed and said is the proper instruction. The second argument was on the static 99R. As stated, the qualified examiners did tell the jury what the average sex offender or recidivism rate was, including at page 792 of the transcript. Dr. Cookman
What did he say?
specifically testified that the average rate is between 5 and 15%.
I don't understand why you would have a number for well above average of 17.8% and a number for average that ranges between 10 and 15.
I think what they're looking at is the 5 to 15 is a confidence interval. So the actual average that they say is the average rate falls somewhere in between that. The 17.8, there's a confidence interval that falls somewhere in the middle of that range.
But they weren't instructed, or I suppose have a statistician come in with a blackboard and try to explain what a confidence interval is.
And the labels themselves were fairly used.
So average is between 5 and 15%, they were told. I have no idea what average is.
Right.
And the static 99 says 12.86 is above average.
Correct. Because
okay, so now how those can't both be true?
Well, I think it is because with the average, again, 5 to 15 is I always have trouble saying this, the confidence interval, but the actual number, when you look at the average, is lower than that. It's a little bit below 10, I believe.
And so, but with low confidence, you get good confidence somewhere between 5 and 15. But if you pick this number somewhere in the middle there, around 10, it's low I mean, I don't, statistics is not like my long suit here, but it does seem odd to me that they're being told above average is 12, but average is between 5 and 15, and so 15 is within the average range, but 17.6 is well above average. That's only one of the issues I have with this. I'm having a hard time squaring what a jury is supposed to figure out from this.
Well, and that's why the evidence on the labels is extremely limited. It's used in the qualified examiner reports and in Dr. Johnson, who was the appellant's retained expert. Her report also lists the same information.
Okay,
But-
so in George, the SJC struck down the use of the old labels.
Correct.
Which were something like low, I don't know if it
Low,
was
medium.
average, medium, and high, and very high or something, and
Yeah,
they said,
correct.
you can't say that.
Correct.
Why can you say well above average?
Because the problem when George, when they looked at the labels then, is that they weren't based on anything mathematical. The issue for the drafters of the static 99R that's addressed, and this is addressed in the George case, is that the new labels are tied into
Wait.
mathematics.
They've just changed the names of them. They're all exactly the same, right? That is,
Oh, there's-
one is 0 to 2. I mean, I'm just looking at something in evidence, Cookman's report, and it says level 1, this is at page 66 of the appendix, second volume. Level 1, very low risk, scores of -3 to 2. Level 2, below average risk, scores of -1 to 0. Average risk, scores of 1 to 3. Presumably that was what it looked like on the old one, just had different words there, low, high, and so on.
Right, but they weren't tied into the average.
Well-
And that was the whole basis for the change in the scoring.
So
by the
instead of
drafters.
calling it moderate risk, it's now called average risk.
Average, and they tell you what the average is, and so that you can see where
I just have a hard time seeing how if we if we show this chart to a juror, and level 1 is called very low risk, it doesn't say way below average, it just says very low risk. And then we go up from there, and then we say, oh, this person, we don't have a category above that. That's our top category, well above average.
above 6 and above.
Yes,
as a
but it
score.
also says, there's a list of the levels, and it doesn't go anywhere above that. How is that not going to tell them? Well, then there's a likelihood he's going to do it again. Why doesn't the label well above average mean to a person, oh, this is, well above average, right? And all they have to find is, likely? Are they likely to reoffend? Well, way above average. It doesn't get any worse than that.
Well, because they're told the figure, so they know what the recidivism.
I understand that, but they did, that part was allowed in Georgia. I'm just asking about the use of the label, and I'm not saying that I've figured out whether it's prejudicial or not, if it is an error. But I'm having a hard time with why the label is really any better when it's the top label with nothing above it. You don't have to call it high for it to be the top level. The
Right,
worst
now
person
it's
in the
well
world
above.
gets that.
Right, well above average,
Yeah.
and they're saying anything.
And well above average sounds like, that's no good, right? Right?
But it is
Well above.
tied, the prior labels, there was no mathematical calculation at all. Now, average
I
is a
think with the
math.
prior labels, there may have been a mathematical, but in just reading George, it looks like that was not provided to the jury. None of
The
the
labels were-
math was provided to the jury.
Those labels themselves, which are low,
Right,
medium, high, and high,
Right.
they don't tell you anything as to, because you don't know what the average is. So now that
Well,
it's
high
average-
tells you high, and well above average tells you high.
Right, but you actually now have an average, and you're looking at it.
Although someone's judgment about what's well above average, all right, so if the average ends at 15, someone has to tell you 17.26 is well above that. You might have thought, oh, I thought it would be 80, would be well above, and they're saying, no, 17 is well above, right?
Right.
I think it's actually quite tricky. I know we have these unpublished opinions, but
Right,
sooner or
there's at
later,
least three-
someone has to actually give binding guidance about they're fine or they're not fine. So, and it seems to come up. There are 4 unpublished opinions. It seems to come up a lot. Well, of course it does, right? It's an open question.
It does. And based on the George case, which did not overturn George's verdict of sexually dangerous, was not overturned using the old labels, because the limitations on the static 99 are explained. It's really just one data point of many, and the jurors went on, the experts went on to talk about the mental conditions that the petitioner suffered from, the dynamic risk factors, which are the factors.
But isn't it the only, so I hear that, and I understand that that's what the cases say, but if I'm being asked, as your brother points out, to predict the likelihood of reoffense, right?
Correct.
And I think the one sort of concrete data point with a percentage attached to it is this. Don't you think it gets attention of the jury?
That percentage, the 17.6? It does, but because of the explanation from the qualified examiners, because, I think it's more likely that a jury is going to say, well, 17.6 is not, and that's what is always argued, is that 17.6% isn't likely, even though...
But luckily, they have an expert to tell them it's well above average.
Well, it's not just, it's the drafters of the static.
Yeah, but they hear it through the experts, I assume.
In the Boucher case, says, the Commonwealth need not prove to any mathematical percentage that the petitioner is likely to reoffend.
Let me ask you about the Boucher case. I was shocked by the Boucher case. I'm really surprised by it, because it has this one word, likely.
Right.
And then they say, like, oh, if it's really bad, less likelihood is likely. And it's like, that's just not what the word likely means, but we're bound by it.
But for these purposes, that's what their calculation was.
In a case like this, is it your position that any risk is too great?
No, but I'm
talking about the cookie issue here.
Basically, what Boucher says is that in determining what is likely, you can look at the
seriousness,
the relative certainty, and the relative seriousness, as well as the possibility for successful intervention. That third factor, among other factors, but that factor wasn't really at issue here because the petitioner really had not done much of treatment and hadn't progressed in treatment. So this was just given an example because it's kind of different when the jury hears, likely, and then hears you're going to look at...
Maybe you couldn't have used the poison analogy if this person only was guilty of non-contact offenses.
I think he can't be held if he's only guilty of non-contact offenses.
There would have to be, for him to be held on non-contact sexual offenses, there would have had to been evidence that it would likely put the subject or the victims in a...
fear of a contact offense.
Imminent physical contact.
So if the lawyer had specifically said in closing, any risk is too much, you would agree that that would be error?
I don't know that it would be error because...
It would be misstating the law.
But you talk, well, right, but there is no percentage of the risk. So based on Boucher, where it says the Commonwealth need not prove...
Well, these are pretty grave crimes, so if they're what he's going to... What we're looking at, risk of reoffense of these kinds of crimes, then...
It's pretty high.
Maybe it is a poison cookie, but I'm not... If you give me a barrel of 200 cookies and say just one of them's poison, I'm going to have a pass on that, right? Like, that's too much risk. I know it's only 0.5%.
And it was really just trying to illustrate to the jury how because it's kind of a foreign concept, how the seriousness of the harm relates to likelihood, where just showing two different harms, two different outcomes. Because, if this had been a case where the likelihood of the criminal offense was going to be armed robbery, that wouldn't be enough for a sexually dangerous person's case or anything else. But where it's...
No, but the jury wouldn't have decided that. That would be kicked out.
Right. But where it's, a sex offense, that threat is so high and the future harm is so high and the likelihood of successful intervention in this case was very low, it was really just meant as a way to illustrate the interplay of those two.
Can we move to, isn't there a Mackey violation here?
No, because in Mackey pled to a lesser included offense, never admitted the conduct that was considered sexual. In this case, the petitioner actually pled guilty to pulling down or when he admitted the facts, and he admits now in interviews, he pulled the girl's pants down. Now, he says there was no sexual intent, but he says there's no sexual intent to the worst.
Just stop, I want to make sure I understand the record. Your opponent says, of course we don't have the plea colloquy, it was 1974. He's right about that. We don't have the plea colloquy, right? That's not in the record.
Correct.
So the reason you're saying he, quote, admitted the conduct is based on statements that he made during interviews while he was either in prison or
Correct, in treatment and to the
treatment.
qualified examiners.
And what he admitted is, as I understand it, I pulled her pants down because I was trying to grab her, right?
I mean, that's what he says.
Okay.
Now,
But that's all he's admitted to, or that we can say for sure he's admitted to, because we don't know whether the plea colloquy included the pants detail.
so he's admitted to it now, that he pulled the pants down.
He's admitted to the pants coming down in a different context than what the police reports say.
Did they come down? I thought they were just pulled out and
He
torn.
tugged, he started to pull them down.
Yeah, but they weren't pulled
So
down.
what the qualified examiners was that this was a sexually motivated offense, an offense that in the totality of the circumstances manifested a sexual motivation to the offense,
Is that
which is,
otherwise established? Is that what that does?
that was their opinion of this offense. Now, this petitioner denies the sexual components of the worst of these offenses, where there was multiple incidents of penetration. So so it's not inconsistent with his other, when he's talking about his sexual offenses, he says he's never had the sexual intent in any of these offenses. So I think that Mackey is quite distinguishable in this case.
Your time has expired. Seeing no further questions, thank you very much.
Thank you.
Very strong arguments by both of you, very helpful to us.
Thank you.
The case is submitted, I'm supposed to say. So I will. The next case we will hear is, number 23-1041, and this is I'm sure I'm going to pronounce the name wrong, John S. Palys and another. I believe we will hear first from Attorney Collier.
Morning, Your Honor. Let me turn this down.
It's okay.
You might want to bring the microphone a little bit closer to you.
There.
You might want to bring the mic.
That.
Yes, that one, yeah.
Okay. Yes. John Palys was the son of Stanley, and the mother died before all them. Stanley died in 2000, and John died in 2019 at home in a house that was a deplorable condition, had a hole in the roof, outside looked like a jungle. He spent none of his money on fixing and repairing the property. He was receiving about $30,000 a year in dividends from his father's stock, which he never officially was given through a probate. He never probated his father's estate, and he concealed the wills in a safe deposit box for almost 20 years until they were found after he died by an attorney. Judge Donnelly directed further discovery to find out if there's any possible ownership of the stocks by John, like a beneficiary or some other agreement or something outside the will, so that we can avoid this issues. And there was nothing found that would stop it. They had, the father and the son had complementary wills that were made by a licensed attorney in Chicopee, and he put the words heir in the father's will, but not in the son's will. The son wanted to give everything to charity, and the father gave the property to his son and to his heirs and assigns. And
So, well,
I don't understand that. I thought that the complementary wills were identical
no,
in the use of the language to so-and-so and his heirs. No?
and I don't remember that being that way.
can I ask a question?
Sure, sir.
I think we understand your concerns about the first will not being probated, and your argument, although it was rejected by the trial court, but your argument that that language about heirs and assigns actually gives the heirs, I don't know how much, half, I guess. I don't know who the assigns are, what if, when these assignments are supposed to be made. But in any event, I understand those arguments, I think.
Yeah.
Without saying whether they're right or wrong, I think I understand them. But this was a petition for allowance of a will, and the only objections that were, well, there were two objections that were filed, one by Linda Collier and one by Stanton Collier, who I gather is yourself.
Yes, correct.
The judge dismissed Linda Collier's objection, not on the ground that all these arguments were wrong, but on the ground that she never filed an affidavit.
She was.
Okay,
Yes,
and she's the only person of the two of you on the notice of appeal.
that's correct.
But if she never filed an objection, there's no error to dismissing her objection, right? So all those arguments may be interesting, but what do they have to do with this appeal?
Again, I was appealing on the grounds that what they said regarding removing the heirs, because she is an heir still.
Well, I understand that, but all I'm saying is, if she's not a valid objector because of not filing the affidavit, and we think that's right, we don't have to reach any of that. We just say, yeah, he dismissed her properly, so there's no proper party before us.
That's then. Now, we have a real problem, because what happened is, the judge was determined, because my wife, Linda, she filed a probate on the father's will, and they want to take it over, because what happened is, if the John will is held invalid or something, that all the property, the stocks would end up in the Stanley possession, because there was no legal document that showed.
But that's a different proceeding.
It's going to be following this, yes.
Okay, but that's a separate proceeding. That isn't before us right now,
Yeah.
whether John's will is okay, not okay, should be probated by her or somebody else or nobody. That's
Okay.
not in front of us, right?
Okay.
Okay. Thank you. I see no further questions. Thank you very much. We will hear now from Attorney Roundy.
Thank you, Your Honor. Michael Roundy on behalf of the estate. May it please the court. I think Your Honor has the posture of this case exactly right. The only issues before this court are the orders that were entered below and whatever arguments the appellant might have that those orders were incorrect. The only orders that were entered below is the determination of the heirs, which I gather the appellant does not contest, the allowance of the will, and the sort of preliminary determination that Attorney Collier's objection would be stricken because he did not have
Why is that a
standing.
preliminary determination?
It
Do we have a
was-
final judgment?
I'm sorry?
Do we have a final judgment with respect to the probate of the will of John Palys?
We have a decree entered by the court that the will is entered into probate.
And what is that, what is the consequence of entering it into probate? Why is that appealable as opposed to the way I was thinking about this is you enter the will into probate and then there's a personal representative is appointed pursuant to the will, I assume, and then the personal representative disposes of the estate, and then you have a final judgment that can be appealed from. Why is there even where are we in this process?
So that's a good question. Where we are in this process is the history of the estate is a little bit different than many estates. So initially, 2 of John Palys's relatives petitioned to be appointed personal representatives so that the estate...
Yeah, I'm familiar with that. But
be
I mean, I have
probated.
in front of me a decree and order for complete settlement, which is the order that also has an explanation of the fact that Mr. Collier does not have standing to object.
Yes.
And I guess it probably incorporates the prior determination that Mrs. Collier is dismissed because she didn't file an affidavit of objections as required by the law, right?
Yes, sir.
Is this an appealable judgment or an appealable decree?
I haven't made an argument that it isn't.
Well, it doesn't
But I
really
don't know
matter
the answer to
because
that
if it's
question.
not appealable, that's
We have to
then
figure that
we have to
out.
dismiss that.
So I think, I guess in some sense it may be appealable because that is his last chance to contest the idea that the will itself should be probated at all. But he's made no arguments in
Let
his
me
briefing.
ask you about that. Let's pretend for a moment that, and I'm not saying this at all, but let's pretend for a moment that the judge below was wrong about how to read heirs and assigns. And so, in fact, John's will gave half of everything he had to Stanley's will. I don't remember which.
Stanley's.
Gave half to John and half to heir. Of course, he doesn't have heirs. He's alive, but all right, half to the people who would eventually be his heirs. And so there's a pile of stock sitting in a room somewhere that belonged to Stanley. And they're concerned that it's going to be put into the estate of John when really half of it belongs to them. What does that have to do with probating the will? Like I mean, surely there have been estates in the past where someone showed up and said, yeah, the grandfather clock is mine. Hey, trustee or whoever's doing it, hey, personal representative, I see that you're dispersing all this stuff, but before you do, let me just get my grandfather clock out of here. Now, the estate might say, no, it's not your grandfather clock. How is that ordinarily litigated, if it comes to litigation?
I think it has nothing to do with whether the will should be probated, and I think the judge below actually did not make that determination. I would regard what the judge below did as dicta, and he clearly says that issue is not before me, before he runs through about one paragraph of short analysis.
But so how does, because I actually don't know, how does someone contest that a personal representative of an estate has accidentally or otherwise scooped up into the estate some property that doesn't belong to the decedent?
I see, Your Honor. After the will is entered, the PR gathers the assets of the estate, or he's already begun gathering, but
Sure.
he continues to gather, in this case, the assets of the estate. And at some point, he goes to the court for what the title of the petition in this case is, a final settlement, an approval of the distribution of the assets of the estate. And at that point, when that petition is filed, another objection could be raised that assets that he's taken possession of are
So now you're starting to
improperly.
answer the question that I asked. That's called a final settlement. So if this order says it's the final settlement, it's probably a final judgment, right?
Well, I don't think so, because the petition is a form, okay? And on the form, there are check boxes, and you see this on the decree as well. And the checkbox for actually approving a final account is not checked by either the petitioner or the
On the
judge.
document I just waved around, it's not checked.
Right.
And so someone who's a practitioner in this area would know that hasn't been done yet. There's more work to be done on the estate.
That it's called a petition for final settlement, but it's not really. It just is the mechanism that the petitioner
Okay.
used to
I
get
have
the will
one other
allowed.
question. The language that your opponent is so concerned about in Stanley's will that says to John Palys and his heirs, that language is not in John Palys's?
It is in both wills, is my recollection and understanding. It is They were identical reciprocal wills except
Well,
for...
we'll look at them, obviously.
Yeah, sure.
I had thought it was in both, but in John's will, that avenue isn't, because it's only if he predeceased his father that would be operational.
wouldn't matter.
So it just goes into the Shriner's box.
Right, right.
I see nothing. Do you have more for us?
No, Your Honor, I rest on the
Okay,
papers.
I'm afraid we have no rebuttal in our argument. That's the rules here. So thank you very much. I think we understand the case, and it is submitted.
Thank you.
This brings us to our final case of the day, it not being morning anymore, which is number 23-1069.
That happened.
Unlike the form in the probate court, you can probably get a clock button here. I don't know how you fix the form in the probate. Number 23-1069, which is in the matter of minor. I remind counsel that this is, of course, an impounded case, so we use pseudonyms or descriptions for the people involved, not their actual names. I also am told that there will be a division of time among the appellees, with the guardian's counsel taking 10 minutes and then the child's counsel taking 5 minutes. Is that your understanding as well? Very good. And we will hear first from the attorney for mother, and that is Attorney Rubin.
Thank you. Good afternoon, Your Honors. Jeremy Rubin for the appellant mother. The critical question, of course, here is whether the mother was currently unfit at the time of trial, because the allowance of the guardianship is premised on that very fact. And understanding what current parental unfitness means is the pivotal inquiry. And according to the case of Home for Little Wanderers, it means grievous shortcomings. And that phrase, those words, have to mean something. Can't mean mother was a bad parent, mother wasn't a good enough parent, grandmother was a great caretaker, grandmother was the better caretaker. It has to mean these synonyms: grievous, appalling, calamitous, intolerable, heinous, monstrous, unbearable, and tragic. Was mother any of those things at the time of trial? My answer is no. She was engaged in services. She secured housing. She had therapy. She took a parenting class. She acknowledged mistakes that she had made, both in relationships and some decisions she had made.
Counsel, it sounds like a lot of what you're saying is the judge's ultimate decision and the weight the judge gave to certain things. Are there any actual findings of the judge that you say were clearly erroneous?
My argument is more the totality of the findings versus specific findings. There were two events, one procedural and one an event sort of quasi-procedural if you include the DCF's participation here. The trial court at the inception of the case in 2000 denied the maternal grandmother, the petitioner's, request for temporary guardianship, finding that there was insufficient evidence, and the allegations that were brought forward were the same ones that rode out through the course of the case, that the judge specifically found mother was not in an abusive relationship. And I would also alert the court to the fact that some 6 months before the trial, the DCF, whose involvement was because of 51A concerns, et cetera, that were commenced in this case, they closed their case, meaning there were no protective concerns. 6 months before trial, there were no protective concerns.
And they closed the case, the child was not with the mother, correct?
Yes.
And had not been with the mother for how long?
I don't know an exact answer to that, but it was some time, months at least.
The trial took place in what, 2022?
Correct, yes.
And as I remember reading, child had last lived with the mother in 2019?
Sounds right, yes.
So when you say there are no protective concerns, child was with the mother's mother and had not been with the mother for 3 years.
Correct.
Can I ask, well, maybe we'll
How
respond,
much was she seeing How much were the mother and the child seeing each other during the time period that the child was not with the mother?
So there were swaths of time when the mother delegated some.
Lived with her grandmother, or lived with her mother, right? There were times when she lived with the mother, but they
Right.
were...
In fact, when she was pregnant with child, she, I believe, was living with the maternal grandmother and her husband, and specifically there was some representation they had made that when the child's born, it would be too much for us, for you to continue living here. So I think the nature of that relationship is an important one. The mother and the maternal grandmother was a very trusting one. The mother had a history of trauma, no question about that. She was involved with the DCF as a child, and the maternal grandmother was her adoptive mother. And she trusted her enough to the point where she delegated a lot of responsibility. She, I believe, gave her a caregiver affidavit, wanted her to be very involved. So, correct, Your Honor, that it is the case that she didn't have the child specifically living with her, but I think there was sort of a confluence in that relationship in the sense that...
Is it correct, though, that the child did not live with the mother from 2019 on? And if that's correct, how much contact were the child and the mother having during that 2.5, 3 year time period? Was there regular visitation? You know?
I
I
think
had
it was
trouble
regular
pulling that
visitation.
out of the briefs.
Right. I don't have a specific answer. I can supplement at a later point, but...
And another question I had was, there was a period where the child was with an aunt for 11 months. Is that right?
Yes.
Was that between 2019 and 2022?
I believe it was, yes.
And there's a representation in the brief that during that time period, the mother saw the child only once, or didn't see the child for 8 of those months, or something like that. What are the facts that are in the record on that subject?
So
I gather the aunt lived a long way away, right?
I do know that there was some procedure where there was at least one contempt that the mother had filed, and I think there was some concerns that the maternal grandmother had during the period of COVID, that mother was or wasn't doing things that she felt were putting the child at risk. So I think there was a little bit of back and forth during that period of time.
That's before the child goes to the aunt. That's when the child is with mother.
Mhm.
I believe, is when maternal grandmother was filing, well, I might be wrong about that. It may be that those were visitation violations. Okay.
Let me ask you this. You've used all these terrible adjectives to describe a mother who is unfit. But haven't we also said that an inability to provide proper care for an individual child without maligning the character of the mother or her love for her child may render a parent unfit? We've said that, right? And the SJC, more importantly, has said it. Do you agree with that?
Well, inability is a softer sounding word than some of the adjectives I used, correct?
Sure.
But it gets to the heart of...
Okay, and we have evidence here from the credited evidence by the judge here from the therapist that if the child had to live with mother, it would be emotionally devastating, and that there would be some pretty devastating consequences, some phrase like that, from being removed from the child's current placement. If we credit that, that seems to me it's not a whole story at all. I think the whole story matters a lot. But that's some pretty heavy-duty problems, right?
Yes.
Okay.
Ultimately, though, the question is not who is the better of these two caretakers. The question is not whether maternal grandmother has provided great loving support for the child, because the answer to those two questions may not get to the vital question, which is the mother. There's a constitutional right that the mother has, that every mother has.
The mother's constitutional right has to be balanced against this child. And as a follow-up to Justice Rubin's question, if a child has fragile physical and psychological health, if this mother, because of those child's issues, can't care for the child, wasn't this a fair decision by the judge?
If, of course, if the answer to that's yes, yes. But I don't think the answer to that was yes, to the extent that the mother was capable and she was engaged in services. And what's the purpose of services but to improve oneself as a parent? Was she perfect? No. This was a very traumatized mother and should be very thankful to her adoptive mother being there and helping as much as she did, yes. The reality, though, is that she was not unfit at the time of trial.
But the judge made a finding that the mother's income and housing was unstable. And you said at the beginning that you didn't contest that any of those findings were erroneous. So if that's a fair reading of the findings, what do you say about that?
What I said, I believe, is that I didn't contest any of the specific findings, but in their totality, I do contest them. And I want to comment on the findings as well, which is that the judge speculates that, yes, mother has a job now, mother has housing now, which she did at the time of trial, but somehow I think in the future she's not going to be able to maintain this. And it's that type of speculation, I think, that runs in contravention of what the standard is here.
Well, but I think that was a conclusion based on the expense of the apartment and the absence of a clear source of income that would be able to support that expenditure. I mean, I don't think it was pure speculation, just, characterologically based. I think it was about money.
Well, but, there were other sorts of questions that perhaps could have been asked, like, were there other people who are helping you here, or where's the money going to come from? I think it almost felt as if she had given up on the mother, and this is the same court system, the same judge who at the beginning, at the inception of the case, had said, look, there's not enough here to give the maternal grandmother.
Well, doesn't that actually cut the other way? Suggest that the judge is not cavalierly doing this, that the judge's initial impulse was that's not enough. I mean, obviously, I don't know how. Right?
Yes,
it
no,
raises two inferences.
Well, I think that there would have to be some substantial evidence that these same allegations, which came in at the inception of the case, had now morphed into something so much larger than what they were at that point.
There's a lengthy decision with a lot of findings and explanation in it.
I'm sorry, I missed that.
There's a lengthy decision with a lot of findings and explanations in it.
There's 20 pages of
Yeah, I
findings.
know it's not like a termination
anymore.
of parental rights
Right.
kind of decision, but
So,
There are things that had developed over those 3 years, I think it is, from the inception of the case until he hears the trial, right? I mean, there's a finding, which that the child has severe physical reactions and fears when the child is with the mother. I imagine there was no evidence of that at the temporary hearing. There's a finding, there are other findings as well that appear to have developed over time.
but I think your question cuts both ways, Your Honor. The earlier one, which is the child hadn't been with the mother for a number of years, there's not really enough data to draw the conclusion of how the child would react if, in fact, the child lived with the mother. Isn't that a fair question to ask? If we haven't tested that in the period of time from when the case was commenced, and the court found there wasn't sufficient evidence for temporary guardianship, and the DCF subsequently dismissed its case, no protective concerns, aren't we lacking in the data that we might need to make that type of determination? So,
Child initially is given to the aunt because the mother decides that that's the appropriate step to take because of physical abuse that's taking place in the home, right?
yes.
And then at some point the child comes back to mother and grandmother for a brief period, and then mother leaves the child with grandmother. What was the reason for that? That happened in 2019. I'm just trying to get the timeline, which I had trouble following.
So, admittedly, the mother was in a series of poor relationships. Admittedly, there's no hiding from that. And one of them in particular was a very abusive one, a very disturbing one, which she ultimately ended, and she learned and benefited, I think, from her experiences in these relationships. And to answer this question, I'm not sure I can specifically give the reason, but I think it was a combination of a lot of the reasons that brought the case in originally. in good faith by the maternal grandmother, which is the poor relationships, the mental health, et cetera, the trauma. And to her credit, I think she recognized that maybe there were certain instances when she couldn't parent alone, when she needed the support that she was so desperately crying out for.
Okay.
If there are no further questions, I'll stop there.
I
Thank you.
see none. Thank you very much. We will hear next from Attorney Sandberg.
May it please the court, Mary Sandberg for the appellee maternal grandmother, the guardian in this case. Your Honors, we've heard about what the grandmother had to prove at this petition for guardianship, and I would point out that the temporary guardianship, the grandmother's petition for temporary guardianship was denied from the onset, but the allegations at that time were very different than the assertions that were made later in the case, and the case for mothers, for the proving that mothers was unfit at the time of trial to parent this child, and that it was in the best interests of the child to remain in the custody of the grandmother who had cared for her since 2019. At the onset of the case, when the petition for temporary guardianship was filed, the allegations were a little bit different. Mom had been smoking in the car. There were allegations that mom had smacked the child and that she was continuing to be in unsafe relationships that included some domestic violence. By the time of the trial, we would argue, Your Honors, that there were 4 areas that showed that there was not only a pattern of unfitness, mother's parental unfitness, but it continued from the day that the child was born all the way through the hearing of the case and the evidentiary hearing, which ended in 2023. First of all, the 4 areas where it shows most clearly would be in the child's education. Grandmother was the one who enrolled her in preschool, both here in Massachusetts and in Florida. She was the one who made sure that the child was homeschooled when there was homeschooling during the pandemic. Mother, and the evidence showed, did not participate in the child's schooling at any time. So that was one of the factors that wasn't addressed at the time of the temporary hearing. Another area was the child's medical needs. The grandmother took the child to all of the child's medical appointments. She had some special needs. She had some problems with constipation, had been referred to a gastroenterologist. Mother did not attend to any of the medical appointments, did not ensure that the child was medically treated. In fact, knew the name of the pediatrician, that was about it, attended one of the medical appointments. The next area would be the child's need for stability. It became worse over the child's life. Mother's history of moving with the child. First, she moved with her when the child was born to friends in Connecticut. Then she moved on to a cousin who lived in Worcester. Then she stayed there for about a year, and then to another cousin in the Worcester area, and she stayed there for a year. Then she moved in with the boyfriend who was abusive to both mother and the child. And there was a history here, and it's in the record, about the child being
Your
beaten.
position is that what was shown was grievous shortcomings.
Grievous shortcomings all the way through in all of the areas that the child's, that affected the child's
child was
life.
being taken to medical appointments, and the child was being schooled, and the child was being taken care of by her mother, right?
By the grandmother.
Right.
Yes.
So,
And mother didn't participate, so we don't have any evidence of her
but
being.
non-participation, is that a grievous shortcoming when the child, I mean, if a parent elects to have the child brought up by a nanny, and the nanny does all those things, that's grievous shortcomings?
It is when the mother is asking that this petition for guardianship should not have been allowed. She is asking that she be permitted to parent the child full-time, although she had been, and the judge did find that she
in my
was.
hypothetical, in my hypothetical, those are not grievous shortcomings, even though the parent has not been taking care of the child on a regular basis, are they? I mean, that hypothetical occurred a lot in older days. I'm old.
I'm old.
And I don't think that anybody would take the position that that rendered the parent unfit.
No, but that differs. I mean, a parent would voluntarily place the child in the care of a nanny and maybe off traveling and having, jobs that took a whole lot of time. But that's not the case here. The mother was given a second chance when the temporary guardianship was denied. She was given a chance and encouraged to take part in the child's life, encouraged. She was the legal custodian of the child all the way through the case, and yet she failed to take part in the child's life, and the judge did find that there was an indifference here because she had the opportunity to take the child and to ensure that she was educated. Her health issues is probably the area where it is most evidence that the unfitness and the best interests are coinciding, because the mother didn't ever appreciate the trauma that the child had suffered. The grandmother enrolled the child or engaged the child in therapy. The child had been in therapy since 2019, and the mother had never participated in the child's therapy despite being encouraged to do so by the court and by the grandmother.
The grandmother was never a nanny, was she? She's not the nanny of the child. She's the grandmother who's taken overall responsibility, including things like enrolling her in schools and medical treatment, which I think a paid nanny probably can't do, right?
Exactly. And there was a caregiver affidavit that was indicated earlier today. The mother had given her some responsibilities, but these were parental responsibilities. A nanny is not someone who would take over all of the custodial, I agree with you, all of the custodial duties. And the mother had these opportunities and failed to take advantage of her time with the child. And to answer the question that was answered earlier, there was a temporary order for visitation with mom and the child, or it would be parenting time as opposed to visitation. It was at that time, mother was working as a CNA and had the child 4 visits according to the temporary order. Starting on the first day that she was off, she had one of those, I believe it was a 2-day, 4-day kind of a schedule. So the first day that she had off, she would have the child overnight and then sometime on the weekends. But there was a long history, and it's in the record, of the mother failing to take advantage of her time with the child. Not only during...
She had visitation rights from 2019 to
Yes.
2023 or 2022, and you're saying the record will show that those were exercised sporadically.
Exactly, yes.
Isn't there evidence that she also told the child to lie to her therapist?
She told the child not to disclose things to the therapist, and at one point, this is one of the most telling things as far as interfering with the child's therapy. When the child had all of these reactions, such as vomiting, panic attacks, and to the point even at one time where the grandmother had to take the child to the emergency room to calm her down. She thought she saw the gentleman again who had abused her and hit her with the belts, and initially mother had denied that had ever happened, although it was in the DCF record that she had witnessed it. But now I think I've lost your question, Judge Rubin.
It's late.
My question was about her instructing her to lie to the therapist, and you said there was a telling.
Oh, yes. So back on that train, she characterized the child's physical manifestations as fake, and then told the child, don't talk to the therapist about this. That was in the record as well. So if a child is still experiencing all of the trauma from the trauma was attributed to being left alone at relatives, not sure when she was coming back, and that the time with the aunt in the Worcester area was a period of 7 or 8 months where mother just failed to visit with the child. She had a couple of phone calls with her, and that was it. So if a parent fails to recognize the child's special needs, and in this case, her mental health needs are very prominent, and her need for stability, we would argue that based on all of these factors, that it's the totality, it's what we call the constellation of experiences, factors that would render mother unfit to care for this particular child. This child needs the stability to remain in the home where she has been cared for solely since 2019, and we would ask that this court affirm the judgment granting her guardianship.
Thank you very much. We will hear finally from Attorney Bench.
Good afternoon, Your Honors. I'm Nathan Bench. I represent the Appellee child. The child is a 9-year-old girl scarred by domestic violence, and she wishes to remain with her maternal grandmother as guardian. Currently, mother's parenting ability is incompatible with the special needs of the child. This is because of, my sister mentioned, the diagnoses of PTSD and generalized anxiety originating from physical abuse and essentially being abandoned for a period of 8 months for mother to continue her relationship, her romantic relationship with the physical abuser. We do have evidence.
That's the evidence. Let me make sure I understand what you're referring to. That's the evidence that there was physical abuse of the child in 2018. Mother's reaction to that was to bring the child to the maternal grandmother's house.
That's
correct. Maternal
correct.
grandmother then placed the child with an aunt, and the record says that the mother did not have contact with the child for 8 months at that point?
That's correct. That's mother's testimony was to that effect. She did not have contact for 8 months with the child.
Child at the time was 2?
That sounds about right. It was September 2018 when the child was moved, and shortly after that to the aunt.
How recently have you seen your client?
I spoke with my client last week.
Okay. And I assume she's still in the same...
Correct. Her position remains that she wishes...
No, but I mean physically, she's still with the maternal grandmother.
Yes, yes. Correct. Excuse me. I did want to speak to one point about the evidence of how mother's care affects my client, affects the child, because mother has had substantial time with the child during the pendency of the case. Mother's care exacerbates the child's symptoms of PTSD and anxiety. Specifically...
This is in the record?
Correct. We have reports from the child through the therapist that the time in mother's care, she sees the housemate and witnesses a verbal...
So there's a tension here between the notion that her contact with the child has been sporadic and that her contact with the child was sufficient so that it would generate a reaction as to which there was evidence. What does the record show as to how often she had contact between, this has got to be between 2019 and 2022, right?
So there is a finding that mother had more or less consistent visitation with her visitation schedule. We don't have, I haven't seen the specifics of how often that is. I do want to speak to one point there that often mother, while engaged in visitation, has also, and this is something that the child has reported deeply distresses her, is mother will commit to attending an extracurricular activity or coming to visit, and it will fall through, and mother will have an excuse, and the child doesn't find that credible. And again, with the deeper fear from the trauma, that again is kind of speaking towards that best interest of the child here.
Can I ask you about the mom visiting exacerbating the PTSD, which is very sad. I think we can all acknowledge that. But can we hold that against the mother? I mean, she's visiting, which if she wasn't visiting would be held against her. She does visit, and the child is upset by it. What do we do with that?
That's an excellent question. I think, as my sister said, mother hasn't engaged in therapy with the child. And I think that that's exactly it, is the method that mother's using. You know, instead of engaging with the child, engaging in therapy to overcome this trauma, both of them having a background of trauma, mother dismisses the child's special needs. And I think that that is the most telling thing here with this particular child, is that rather than engaging with the child's special needs, mother has shown throughout the case that she's unable to do that. I would argue that with some of the examples in my brief speak the loudest to fitness for this particular child with her particular background.
Your time has expired. Thank you as well. These are very difficult cases for us and, of course, for the parties, and we very much appreciate counsel's assistance in helping us sort our way through them. So thank you all very, very much. The case is submitted, and that ends our sitting for this morning. So we now stand in recess.
Court all rise.